We are going to start, and let's wait for 5 seconds to start YouTube broadcast.
Dear friends, dear colleagues, dear like-minded people and opponents, it's a great honor for me to open the 6th Business and Human Rights panel discussion during the 6th Kharkiv Legal Forum. And the panel discussion is my annual chance to bring together my favorite business and human rights names on one round table. First of all, some technical details. We will have translation today, so you can use English or Ukrainian channel. Also, we have relevant information about translation in the chat. Please use it. And I would like to say some words about Kharkiv Legal Forum. Kharkiv Legal Forum started in 2017. In previous years, we focused on the perspective of adoption of the National Action Plan on Business and Human Rights in Ukraine. We discussed the best corporate practices. We discussed regional trends and challenges. We also discussed gender issues in the context of business and human rights. The role of digital tech and many other issues. And I will be happy when we meet again at this round table in Kharkiv on our 10th floor in our library of our Yaroslav Mudry National Law University. I'm thankful very much for all our partners. Some of them are with us from very beginning. International Visegrad Fund supported our first Business and Human Rights Roundtable in 2017, and we have its support today as well. In 2017, it's the first time we communicated with Polish Institute for Human Rights and Business. At that moment, we didn't know how many joint initiatives, projects, and events we will implement together. Since 2018, we cooperate with Danish Institute for Human Rights, with Parliamentary Commissioner for Human Rights in Ukraine, with National OECD National Contact Point in Ukraine, with Global Business and Human Rights Scholars Association. Since 2019, we cooperate with European Business Association, with Modern Women, with Center for Social Action, and with Business and Human Rights Journal. And this year we are preparing together with Yevgeny Letner-Chernich and Beata Farachik the special issue on business and human rights in Eastern Europe and Central Asia. In 2020, we founded together with Beata and Yevgeny Regional Association on business and human rights in Eastern Europe and Central Europe. This year, UNDP in Ukraine, within the Business and Human Rights Project, with support of Government of Japan, supports our event, and this partnership means a lot for us. And my special thankful to the Wageningen University and Research, to the law group who is co-organizing this panel discussion this year. Dark times always reveal good people. Thank you all our partners for your support and for your solidarity. Solidarity is key concept for our today's discussion. We say solidarity when it comes to granting Ukraine the status of an EU candidate country. We say solidarity when sanctions are imposed in connection with a full-scale aggression. We say solidarity when European companies provide assistance to Ukrainian refugees. We often use the term solidarity also in broader context. there is a recent discussion of social solidarity, in particular in the context of possible conflict between the general interest of the community and the individual interests. The European Court for Human Rights uses the concept of legal duty in the name of social solidarity. In all these cases, we use the concept of solidarity. But what do we mean by solidarity? And what can be the legal dimension of this concept, especially in the context of global challenges, war, climate change, pandemic, and others? And finally, and most important for our today discussion, how should the corporate responsibility to respect solidarity be exercised, and how can or should business balance individual rights and the demands of social solidarity? We will discuss all these issues today, and it's great honor for me to open the floor for people who show solidarity with us for their opening remarks. My great honor to invite Ambassador Petr Mareš, the Executive Director of the International Visegrad Fund. Please, the floor is yours, Ambassador Petr Mareš.
Okay. Can you hear me now?
Yeah, we hear you. Yeah.
Perfect. Thank you very much. And I apologize for these technical problems for the beginning. I hope it will work now. It's a real honor for me to make these opening remarks in such a distinguished forum. It's an honor for International Visegrad Fund to be in a family of such a distinguished donors and supporters of the Kharkov Legal Forum. The topic of today's meeting, the solidarity, is the key word for the very existence of Visegrad Forum. It was somehow put into genetic information of Visegrad countries at the very beginning, 30 years ago, by the legendary leaders of those times, like Lech Walesa, Václav Havel, and Arpad Genč. And I'm very proud to say that I'm sure that it is still with us. It has been proved through difficult times in Central Europe during the floods and various disasters, but it was demonstrated in an extremely convincing way after the bloody invasion of Russia against Ukraine. We are not a rich organization. We can hardly compete with those big donors. I don't want to name them, but you know them. But we are trying to support, first of all, solidarity among small organizations, NGOs, schools, ordinary people. And immediately after the invasion, we called for a program of support of Ukrainian refugees. And I'm proud that it was actually in hours and days when we were able to put together 72 projects coming from small villages, small schools in all 4 Visegrad countries. And we spent €1 million in several weeks to help them. And it was a very good demonstration of solidarity, how we understand it. It means solidarity not by the governments, but solidarity by the people. Another example is that when we decided that for this academic year, the priority for us will be Ukrainian students. It was a bit against rule, but it was a silent gentleman agreement with our academic institutions, and they all accepted it. Okay, this year, Ukrainians are the ones who need it. And we did it, it works, and I haven't received a single complaint by anybody that it was anything wrong. So this is a real honor for us, and this is what we really love to do, is support actions like your forum. And I sincerely wish you all the best, and first of all, the success. And I don't want to be pathetic, but I cannot resist to end with Slava Ukraini.
Heroyam Slava. Thank you very much, dear Excellency Ambassador Petr Maroš, and thanks one more time to International Visegrad Fund. This cooperation is very important for us. And now, a person who is my personal hero will speak. Professor, Vice Rector for Research and Academic Affairs and Strategic Development of Yaroslav Mudry National Law University, Yuri Barabash, who remains in Kharkiv, saves our university, helps many people who are in the critical situation in Kharkiv, and who leads the organizing committee for the forum Science a Day when the idea of the forum came. Professor Barabash, the floor is yours.
Thank you very much, my dear friend. I also join to gratitude remarks from Professor Uvarova, and if you allow me, I don't want to waste the time and follow in Ukrainian, if you allow me to do it. Дорогі друзі, я хотів би від щирого серця привітати.
Dear friends, I would like to welcome you and congratulate you on this very important event. For me, it's a great honor to participate in the plenary session, the panel discussion, and of course, the forum. This is the carte de visite of our university. Despite all the circumstances and the Russian aggression, the university is vibrant, developing, and we really manifest progressive development. Using this opportunity, I'd like to mention academician Vasil Kisil, who unfortunately we had to say farewell to last week. It was his idea with Olena, with other colleagues. We organized this 6 years ago, and we will keep the good memory of this outstanding person who contributed to the Ukrainian statehood. Speaking about our discussion today, I'd like to say that there may be no sustainability without this ongoing discussions on business and human rights led by Professor Uvarova. And this is a research vector of our university. That was a challenge for us because our university previously tried to stick with some legal traditions, and Olena introduced the new qualities, and we received a grant from Jean Monnet Foundation to implement this project. This is the first thematic project in this area, in this phase. And also, we have expressed gratitude to our partners, to Visegrad Fund, and really the panel discussion inspires a lot of interest and respect among our counterparts. The theme to be discussed today is really very relevant, and I am not an expert in the field of private law. I rather focus on other areas, but discussing this models, it is very important. Unfortunately, Ukraine, this is the platform where for the first time in the post-war world, we have to develop management approaches in the context of an armed aggression. Because previously we had theoretical discussions, but now we have to pay the high price, the price of human lives in order to develop these new approaches. And the theme of solidarity is very relevant for me, because in 2019, we announced our vector for European and Euro-Atlantic integration, making the Russian Führer resentful. And there, in particular, the slogan is equality, freedom, and brotherhood. This is from the French experience, but brotherhood, this is about solidarity, and this is what is being demonstrated today by the Ukrainian nation. There is no better demonstration of solidarity but the volunteer movement, to which I am also honored to contribute in Ukraine. When the entire nation united, and we have been supported by all civilized countries in our fight for independence. And when we showcased that we stick to the values that we are even ready to sacrifice lives for. In Article 3 of the Constitution, we speak about the value of life as the key social value. However, we demonstrate that dignity, individual dignity, respect to the individual, that is key. And under these circumstances, we would like to hear this vibrant discussion today, how the world could be transformed in the context of the energy crisis, artificially created in the context of limited resources. It would be good to hear more about corporate responsibility in the situation where the free world has to face a recession. And that is a challenge for business corporations, as very properly described by Professor Uvarova in her paper. They are actually the lawmakers in many aspects now. And also how to develop the new world. Because now we face the challenge to the entire civilization. For the first time during the 70 years after the Second World War, a country that has nuclear weapons and that there was a joke by Zadornov by this respect, but he said that Russia is a country with unpredictable past. So they try to put the future on hold. And this is what we're going to discuss today to achieve certain understanding of how we can counter-oppose us to those challenges, how we can stay in solidarity. So without wasting time, I'd like to express gratitude to Professor Uvarova for her organizing this outstanding discussions year by year, to our partners and speakers who support us globally. Yesterday, Professor Komarova said that all of us have our own front lines. That also applies to education, to civil work. So we need to demonstrate resilience as well as sustainability. And this is being proven by our armed forces. Glory to them, glory to Ukraine. And thank you.
Thank you very much, dear Professor Barabas. And I believe that in 1 year we will, as usual, sit side by side at one round table. And now I would like to give the floor to Professor Josephine van Zeben, chair of the law group at Wageningen University and Research. Law group at Wageningen University and Research was one of the first who proposed to help when the full-scale aggression started. Co-hosting of the forum is just one of many things that we are doing together. And personally, for me, it's a story about a huge support and also about, I would say, very inclusive and transparent and cooperative and supportive leadership. I enjoy watching the leadership, research, and management that Josephine demonstrates. Thank you for this example, and Josephine, the floor is yours.
Thank you, Elena, for this very kind introduction. As the chair of Wageningen University Law Group, it's my great pleasure and privilege to welcome you to the 6th Kyiv International Law Forum. As Elena mentioned, for several years, members of the Wageningen Law Group have been working together closely with the Kyiv University's Lab on Business and Human Rights, and primarily, of course, on the topic of business and human rights. This is a very important pillar of our research program, Law for the Living Environment, which brings together research on environment and energy, food law, but also, of course, business and human rights. So this collaboration, led by Dr. Nadia Bernas, the lead of our business and human rights team, and Dr. Elena Uberova, has already resulted in many rewarding projects for our group, including the start of a joint PhD project. Now, since June 2022, this collaboration has become even closer with Dr. Uberova's stay at our group. Despite the horrible reasons behind this visit, the cowardly and vicious attacks on Kharkiv and its people, as well as on the Ukraine more generally, we're very grateful for her enriching presence in our group. And we are therefore particularly grateful for the opportunity to co-host the Kharkiv International Law Forum in this difficult time and to help facilitate the discussion of crucially important issues for the region and globally. The program of these 4 days, to me, shows the many challenges that we face in the years to come. At the same time, it shows us the wealth of experience and the dedication of the international legal scholars and practitioners in the region. And this makes me hopeful as to our ability to successfully face these challenges, particularly through solidarity, and to create an ultimately better future for our and for future generations. So I look forward to seeing you again during the panel on sustainability and transition, corporate respect for solidarity, and I wish you all an inspiring and educational forum. Thank you.
Thank you very much, dear Professor Van Zeben. And I would like to give the floor to Ms. Olena Kolobrodova, representative of the Commissioner for Human Rights of the Verkhovna Rada of Ukraine on social and economic rights. And I should say the last 7 months have been a time of extreme challenges, and it's a difficult time. And in this time, enthusiasm is especially supportive, and I'm very inspired by the enthusiasm with which the Secretariat of Parliamentary Commissioner for Human Rights ready to work, in particular ready to work on business and human rights issues. So Ms. Olena, please, the floor is yours.
Welcome, dear partners, colleagues, dear participants. It's a great honor and delight to be today with you to discuss this important topic, namely the solidarity in transition and respect to solidarity. It's highly important to share interests and values and standards on both national and international level. Since the start of the full-scale aggression, the European Union and partners demonstrated their solidarity with Ukraine by providing huge military and other types of assistance. At the same time, not only international support is needed, but also the national solidarity, in particular, channeled by the important reforms in the sphere of business and human rights. It is highly essential to implement the UN principles for business and human rights. To this end, a number of various events are being conducted, like the Human Rights Weeks or thematical events and awareness-raising activities. These activities give us a chance to involve youth into the topic, and thus the population demonstrates grown awareness and more responsible corporate conduct. Since 2021, the Commissioner's Office is involved in monitoring of the action plan for implementation of the national strategy on business and human rights. According to the monitoring, it was identified that some recommendations are being efficiently implemented. At the same time, there are still some gaps in implementation of UN principles, and therefore it is important to consider the international experience as soon as possible and to designate a body, national body, that would be in charge of the national action plan implementation, since this plan is an essential element of our striving for the sustainable development. Thus, we propose to develop the National Action Plan, and I would like to say that the Commissioner's Office is open to the dialogue and implementation of new projects for the sake of efficient recovery of the country. The cooperation should be based on the mutual respect and respect for the human rights concept. Today's topic is highly important. However, this discussion cannot be possible without international experience and joint studies of the best practices. I'm sure that this discussion will give an incentive to searching for solutions to resolve some challenges the business is faced with at the time of war and in the post-war time. I wish all of us a very fruitful discussion. Thank you very much for invitation. It was very pleasant to participate.
Thank you very much, Ms. Elena. And I should say that the important role to implement all these actions is played by the project Human Rights Due Diligence in Global Supply Chains, leveraging the UN Guiding Principles on Business and Human Rights for a Just Recovery, which is implemented by UNDP in Ukraine with support of the government of Japan. And we are thankful very much for support of this panel discussion as well. And I don't want to leave words of gratitude to our translators, and I kindly remind to all our speakers that our interpreters are working, and please don't be too fast when you are speaking. And I should say that we work with this team of interpreters since 2017, so it's also a great example of solidarity and collaboration. And now I would like to introduce our next speaker. It's a very important moment for the Kharkiv Forum and for our panel discussion, and it's great honor for us to welcome the distinguished lawyer, Judge Robert Spana, to participate in our panel discussion. Judge Robert Spana was elected... Judge Robert Spana was elected to the European Court for Human Rights in 2000. 13 with respect to Iceland and is currently the president of the court. Before taking up his judicial office, he served as parliamentary ombudsman of Iceland from 2009 and 2010 and again in 2013. He served as dean of the Faculty of Law, University of Iceland, and was appointed professor of law. He was chairman of the Standing Committee of Experts in Criminal Law in Icelandic Ministry of Justice, and also he was the Icelandic delegate to the European Committee on Crime Problems and independent expert to the Lanzarote Committee of the Council of Europe. The speech of President Spano, what role for human duties, obligations, and responsibility in our European human rights discourse actually inspired us for this panel discussion. And I will share the link to this speech in our chat. And now I would like to give this floor to Judge Robert Spano.
Thank you very much indeed, Professor and colleagues. Let me, of course, begin with a heartfelt salute to our colleagues, our friends from Ukraine. We are all at this moment thinking about your struggle for freedom, your battle of good versus evil. You are in the midst of darkness, which I'm sure will, however, end up with you entering the light again. We are all here thinking about you. We are all here rooting for you. We believe that you are demonstrating the kind of courage and bravery which will be written in the history books as emblematic of the kind of society and the kind of courage we want to see in this world. We in the European Court of Human Rights are very much engaged in what is happening, as you are aware. We have been struck very deeply by events. It is a great pleasure for me and honor to take part in this forum. I find it immensely honorable that you hold this forum at this point to talk about important issues of solidarity, of the need for us to think about how we can collectively protect rights, how every actor in society is a part of a collective view of how society should develop. I want to use the morning I have here with you to pose two questions. The first question is, how, if at all, does the European Convention on Human Rights require corporate respect for solidarity? The second question that I would then want to discuss before I have a few minutes for questions and answers would be, what does solidarity mean in this context? And can the European Convention on Human Rights contribute to the development of this ideal? And what is this ideal? Is it a moral concept, or is it even a legal norm which may impact the development in this field? Now, if I turn first to the first question, I think it's important to begin with some basic elements. The first is, of course, that the European Convention on Human Rights deals only with state responsibility. So state responsibility for the protection of human rights. We have long, for those in the audience online who have familiarity with the convention system and our case law, we have long divided these obligations of states into what we call negative and positive obligations. Now, positive obligations are very important for the debate you are having here today, because positive obligations of states require proactive state action to safeguard human rights in horizontal relationships between private actors. So it is through the prism of state positive obligations that the horizontal relationship between corporate actors and their communities can be implemented. Now, we've seen this, for example, in our case law in environmental cases dealing with regulation of hazardous materials and pollutants, cases dealing with employment relationships in private companies, cases dealing with protection against abuse of workers under Article 4 of the Convention. All of these cases are cases in which the state's positive obligation is triggered because the state has failed to regulate intra-private corporate horizontal relationships. Now, that means, of course, that corporate actors, they are not directly under the convention responsible for their actions or omissions under the convention. However, and I think here I want to be very clear, the convention does not operate in a vacuum. The court has for decades said that account has to be taken of all relevant norms of international law. And the court has been quite flexible in being inspired by soft law instruments. So the future, I think, may see an evolution as regards the nexus between positive obligations of states and the evolution of ESG and business and human rights principles. Now, I want to explain this a bit because I think this is, or to put it in more sound terms, we are on the cusp, and I hope this is interpreted correctly. We are on the cusp of a paradigmatic shift in the law, in international human rights law, and even in business law and governance. When I talk about ESG, for those familiar, I'm of course talking about the environmental, social, and governance developments that we are seeing both in law and in business practices. And the way we see these developments is, as mentioned in the concept paper for the conference, is all of the regulatory developments in the form of human rights and environmental due diligence laws. These are legislative manifestations of this paradigmatic shift in the distribution of responsibility for human rights and environmental harm. Now, these legislative campaigns, both at the national level and indeed at the European level, especially within the European Union, may, and I think will, affect upstream the development of international human rights law. Law is always an organism where a juxtaposition of norms upstream and downstream occurs. So when states are more and more engaged in legislative developments which impose human rights due diligence requirements on corporate actors, this will have an impact on international human rights law as well. I would, however, say that we are still in our infancy here. This is a development I think will, and I've often said this development will explode in the next 5 to 10 years for various reasons, which I will come to. I do think in this regard that there is no question that the landmark United Nations guiding principles on business and human rights, endorsed by the Human Rights Council in its resolution 17.4 of 16 June 2011, the so-called Ruggie principles, have been a great catalyst for these developments, along with increased pressure on states as well as corporate actors to react proactively to climate change. Now, in these guiding principles, you see a tripartite framework of principles encapsulated, one, on the state duty to protect human rights. Secondly, the corporate responsibility to respect human rights. And thirdly, the importance of an access to a remedy. And this tripartite framework has already had a great effect on dispute resolution at national level, where we see more and more openness to cross-border litigation and liability for corporate actors for the actions or omissions of subsidiaries within vulnerable communities. Now, in the paper that I see, you mentioned some judgments from the UK Supreme Court, for example, the Vedanta case, the case Okpabi, which is also a very important case where you actually see UK courts opening up for litigation of corporate multinational actors because of actions and omissions of subsidiaries in Africa. Now, what does this manifest? It manifests that we are seeing a merging of two different worlds that historically have been somewhat distinguished. Now, to finalize this first part, what this means in sum, that sound business and governance practices have to be adapted now to take account of this new societal and human reality, where sustainability of human endeavors, including and in particular in the corporate world, has become the preeminent requirement. And before I move to my second question, let's for a moment unpack a bit this statement. Historically, as we know, business practices have been based on short to medium term decision-making to maximize economic growth for the corporate actor. That is the nature of the internationalist globalized system of trade. Decision-making by boards and decision-making by governance actors in corporate entities has therefore been, to some extent, devoid of having to look at the way in which corporate practices impact communities, because the main aim of the corporate actor is to maximize shareholder wealth. Now, that, of course, is as such simply a reality. It is a simple depiction of historical governance realities. But the world changes, and the world and the rules applicable in the corporate sector are always going to be relative to the requirements of political, social, and cultural life. And I think corporate actors have begun to realize that no longer can governance practices be solely limited to short-term or middle-term maximizing shareholder wealth, because long-term, without sustainable business practices, there is simply no wealth to be accumulated, because the world, the community, will not be there for them to be able to continue their practices. Now, this is a mentality shift, and it will take time, but it is clear that more and more, at least more and more multinational corporations and those willing to engage in business practices, in particular in vulnerable communities, are taking this into account. So this brings me then to my second question. What does solidarity mean in this context? And the notion of solidarity, which is the concept used in your headline, Sustainability and Transition, Corporate Respect for Solidarity. And can the ECHR, can the convention contribute to the development of this ideal, this moral concept, or even this legal norm? Now, allow me to begin by giving you a brief overview of how international human rights law and the convention articulates human duties and obligations in the overall scheme of rights protection. And this is, I'm building here on the speech referenced by the professor at the outset, a speech I gave at the University of Copenhagen, but I've also given similar speeches in other venues. At the outset, let us look in more detail at the notion of fundamental duties and responsibilities. Where do these notions come from? Probably the most seminal human rights instrument in history is the 1948 Universal Declaration of Human Rights. Now, this is the declaration that inspired the drafting of the European Convention, as we can see from the Convention's preamble. It is interesting to note, and this is, I think, an under-theorized part of the Declaration, that during the drafting of the Universal Declaration, there were fierce debates on the role and place of duties in international human rights instruments. Because as you know, for those of you that are international human rights law experts, the focus is, of course, on rights and freedoms, not on duties. But Article 29, paragraph 1 of the Universal Declaration provides as follows, and I quote, "Everyone has duties to the community in which alone the free and full development of his personality is possible." Now, this, I think, begs important questions. What it does is it articulates an idea that the actual realization of rights can never be devoid of an understanding of duties. They are different sides of the same coin. And this, of course, has immense impact on the development of corporate social responsibility. Because what corporate actors are, of course, doing, they are relying on their rights, right to property, right to pursue a business, but which are, of course, in some international human rights instruments actually defined as human rights of legal persons or rights of legal persons. But at the same time, it is important to realize that these rights can never be fully acceptable in practice unless they are articulated and affect the identification of corresponding duties. Now, there are other, and I referred to the paper here, which I know the professor will send to the colleagues. I want to refer to the Council of Europe's own Parliamentary Assembly resolution, which states that fundamental responsibilities to guide individual action include treating all persons in a humane way, to be tolerant and to respect the rights of others, respecting the rights of others whilst exercising your own rights. Now, this, I think, encapsulates the notion of solidarity. The solidarity of rights is the global organism where rights and duties merge together. Finally, one can see at the national level a number of domestic constitutions which set out individual human duties, although these are more prevalent outside of Europe, for example, on the African continent and the South American continent for logical reasons, because there you have a history of vulnerable communities, indigenous communities, which require duties towards them to be commensurate to the rights afforded to others. So let me sum this up before I conclude with a few comments. While individuals in society all have rights which have to be respected by the state, they do not live in isolation in their community. A community is made up of individuals, including legal persons and corporate actors. And our communities develop on the basis of specific social and political practices. Some human rights must therefore develop contextually by taking account of our collective responsibilities for the well-being of each other. Now, what the European Court of Human Rights has said in a different context to the issue of corporate social responsibility is the court has said that this must ultimately be construed by also taking account of the corresponding human duty, which we in the court have labeled social solidarity. We are all, after all, responsible not just for ourselves, but also for that of others, and in particular, those that are vulnerable in our community. So let me then conclude with three brief conclusions. The first is that the ESG business and human rights developments that I started off talking about are engendering a paradigmatic shift for human rights law, merging merging human rights, public law, and business, company, and corporate law into one holistic organism where one has to view the different sides of these issues so as to find proper outcomes. 2, clever, sound, proactive corporate practices must incorporate sustainable business practices within all levels of governance. And this requires a mentality shift on the basis of certain ideals of social solidarity. Finally, these arguments that I've mentioned are particularly forceful in vulnerable societies, in societies with weak infrastructures, political instability, indeed conflict areas, which you are experiencing at the moment. It is indeed in those types of situations where the notion of social solidarity becomes ever more important for the way forward. Thank you very much indeed.
Thank you very much. And the floor is opened for comments and questions. And you can see Judge Spano, the reaction from our participants. Professor Komarova, please, the floor is yours.
Thank you, dear Mr. President. My question is about the accession of the European Union to the European Convention of Human Rights. As you know, EU is one of the main actors in the principle of solidarity. So will it change some in solidarity, the accession of the European Union to the convention? And are you optimistic about this process, actually?
Thank you. Yes, indeed. I think there are 2 parts to your question. I do think, and I've made this argument repeatedly over the past 2 years, that I do believe that the accession of the European Union to the convention will create a more synergized, more holistic legal space for the protection of human rights. What it does is it brings together the 27 EU states and the 19 Council of Europe states that are all together already in the Council of Europe, but bringing the EU as such into the fold and giving the European Court of Human Rights the ability to provide ex post facto control of EU body decision-making will square the circle, so to speak, and give a more overarching, organic view of the legal space in question. I am positive that this will happen. I mean, my ultimate point is this is a constitutional obligation of the EU. They are meant to accede to the convention. And it is a rule of law environment. And in accordance with the rule of law, accession should happen. So on that basis, I am hopeful, and I hope it happens soon.
Thank you for this question, and thank you for answer. And we have 2 more questions, very brief questions, because we need to let Judge Spano go. Please, Josephine Van Zeben, and then Nadia Bernas.
Thank you so much for this talk. I was particularly struck, so I'm an environmental lawyer, I should probably include that. I was particularly struck by your comments on, collective responsibilities and the collective nature in some way of the exercise of human rights protection and invoking these rights. And there's been a lot of discussion within, I think, the human rights community, but especially in the environmental law community, about using human rights to protect also the environment. Now, naturally, the strength of human rights mechanisms to provide that protection has been welcomed by environmental lawyers. But with that also comes a certain amount of anthropocentrism and individualism in protecting the environment through these human rights. And I was just wondering whether in the future you might see opportunities for these types of protection to become slightly more collective, given that, of course, within the ECHR, we have less focus on collective human rights than we have in other human rights mechanisms, in other parts of the world. So I was wondering what your thoughts were on that. Thank you.
Thank you very much. It is indeed the case that the 1950 European Convention on Human Rights one can argue, is an anthropocentric document. It's all about individual human rights. But let's not forget that the European Court of Human Rights has delivered judgment in about 250 environmental cases. And those cases, to some extent, can be extrapolated as giving some credence to some understanding that there is a collectivity of rights that we are trying to protect through the prism of public interests. Well, the public interest is actually protecting the interests of the collective community. It remains to be seen. I should be careful. We have 3 big climate change cases before the court, as you must be aware. They are now before the Grand Chamber. And I think the question that you simply posed now, to what extent will we see a shift from the anthropocentric origins of the convention into a more collective view of the need to protect human rights on a more global level, is possible under the European Convention, will actually be decided in those cases. I have to leave it at that.
Thank you so much. And
I have 1 more minute. I'm so sorry.
Yeah. One minute. Just 10 seconds for question, please, Nadia Bernard.
I can't hear you.
Me as well.
Okay.
Oh, yeah. Everything is okay. Nadia, please.
Can you hear me now?
Yes, we do.
Yes. I'm hugely inspired by your optimism about business and human rights developments and gendering a paradigm shift in international human rights law. I'm just wondering, how do you see this concretely changing international human rights law? As you know, we have discussions on a business and human rights treaty going on at the United Nations at the moment. But I was wondering if you see an opportunity to have these legal developments happen at the regional level, and particularly through perhaps another protocol to the European Convention on Human Rights. Thank you.
I think this can happen in 2 ways. The first, I tried to allude to in my intervention by saying, the more we see in the European legal space, states and international organizations like the EU enacting legislation in the form of human rights due diligence, requiring private actors to protect human rights, to identify potential harms within their business practices, the more that will have an upstream impact on the development of states' obligations under international law through the notion of a European consensus. Because the more there is a consensus that private horizontal action is a part of the human rights landscape, the more that can have an upstream development in relation to the way the court and ultimately also national Supreme Courts interpret their own constitutional requirements. The second point is, of course, as you know, when it comes to a protocol to the convention, there is a lot of debate in the Council of Europe of a potential protocol related to the right to a healthy environment. Now that, of course, clearly would, if that happens, I'm not going to state a view on whether that is likely, but if that would happen, it goes without saying that that would be a protocol which would implicate clearly business enterprises, because it is, after all, business enterprises which are the main catalyst, the main actors when it comes to the ability to be able to deal with climate change and protecting the environment. I would like to thank you. I really have to go. I have a deliberation to preside. It was great being here. I think this is an extremely good initiative, and I hope to continue to be a part of this environment when I leave the court in 3 weeks, and then I intend to be an active participant in the business and human rights field.
Thank you very much. So we can announce a new business and human rights name, right?
Thank you very much.
Yes,
have a nice day.
Thank you very much. So it's a great start of our panel discussion, and I would like to introduce actually our first session, Solidarity and Human Rights in the European Legal Order. And panelists of this session, all of them are prominent names, and all of them, I could say, my great friends. And I'm happy to have all these people together with us today for our discussion. So Professor Josephine van Zeben, Chair of the Law Group at Wageningen University and Research, Professor Markus Krajewski, University Professor at the University of Ireland, Nuremberg, the Chair in Public Law and Public International Law, John Morrison, Chief Executive Officer of the Institute for Human Rights and Business, Professor Tatiana Komarova, my great colleague from Yaroslav Mudry National Law University, Professor of the Department of European Union Law, Olga Boyka, Coordinator of the Industrial Ecology and Sustainable Development Committee of the European Business Association, and also the author and creator of great Telegram channel on ESG issues. So the session is open. And actually, the first question that I would like to address to all our panelists, and would like to start with Josephine van Zeben. Actually, the key question: what does solidarity mean for European legal order from, in particular, environmental perspective, because as we heard just now from President Spana, it's one of the crucial issues when we are talking about corporate responsibility to respect human rights and to respect solidarity in particular.
Thank you so much, Olena. I actually prepared 1 or 2 slides because I wanted to refer to the Green Deal. Do you mind if I share them? It's really not essential, but I thought it might be.
Of course, you can.
Okay, hold on, let me see. I can quickly do this. Yes, I think this will work. Let's see. Can you see this?
Yeah, we see.
Okay,
yeah,
let me make it full. Let me make it full. Can I do that? Let me make it. Let me make it full screen. Okay, so yes. So basically, your question to me is, of course, very much focused on my work as an environmental lawyer. So my perspective will be slightly different from some of our other speakers. And because of that, and because I understand that this might not be a focus that some of the audience normally has, I just wanted to briefly contextualize my view on solidarity in this area by highlighting what I think is one of the most important developments in this area, which is the European Green Deal, right? And I think here we really have new concepts or new iterations, I should say, of solidarity coming to the fore, because we now have this, I think, paradigm shift, as already mentioned also in the previous talk, of the European environmental policies becoming much more holistic than they were before, right? Before, environment was something that, sure, we should, in theory, integrate into other European policies, but now it's really become this economy-wide goal, which really impacts every part of the European economy. And I think we can see that really clearly here in the goal of the Green Deal to have this modern, resource efficient and competitive economy without any net emissions and decoupled from resource use. Now, within that goal, and this is where we get to solidarity, we can see that in the many different elements of the Green Deal, the technical elements, there's also a very important focus on what is called the just transition, right? And this is to make sure that in transitioning to this different kind of economy, we also, there's going to be winners and losers, and we take along everyone. Right. So this is one part of solidarity, which I'll come back to at the end, because I think this is a really, really crucial development. At the same time, the Green Deal has, of course, been a response in great part to another kind of solidarity, right? Solidarity that comes from what I call mutual vulnerability, right? This fact that
Josephine, sorry that I interrupt you. Did you change a slide? Because we
yeah, sorry. Oh, I'm sorry. You can't see it. Okay, I'm sorry.
Oh, yeah. Okay.
Can you see it now?
Yeah. Now.
Okay. For some reason, it doesn't want to. Sorry, I wanted to show you these main points, but it's not very important. But in any case, what I want to show you here is this idea of mutual vulnerability, right? The fact that through our climatic challenges, we are getting more and more into situations where some people are really needing to adapt to the climate shifts, and that would need solidarity also in our response to these consequences, even if we are not all impacted in the same way. Now, this, I think, is seen more as a type of solidarity that is a trigger to the kind of changes that we're seeing in the environmental and sort of Green Deal context. What has been a really big challenge to this solidarity has been COVID, right? So this is some of the visualizations of the horrible scenes that we saw in Italy and other countries, all of the countries in Europe really, during the COVID pandemic. And what I find very interesting is our solution to these different kinds of mutual vulnerability and the kind of solidarity that this brings about in people. So this is where I wanted to just point your attention to for a second, because this, I think, is a very interesting expression of solidarity that we see now, right? So this is the New Generation EU program, which is one of the pillars, one of the sort of the financial pillars underlying the Green Deal. And it's a way for us to, I think, put our money where our mouth is, in terms of, how are we actually going to finance and achieve these changes that we want to see, and how can we do that in a way that respects the aims of the Green Deal, but also at the same time deals with this problem of winners and losers that is captured by the just transition language that we're seeing. Now, another way to look at this, of course, is through the EU cohesion policy, right, where the Just Transition Fund is a part of, and we can see that a massive amount of the EU's budget is focused on these things. Now, I think, coming back to your question, right, so what does solidarity mean from an environmental perspective? I think it is expressed in all these different kinds of ways, but I think one of the things that we are still missing in the EU, and I think this comes out in environmental issues, but also I think more generally, is the problem that at the moment, most of the expressions that we're seeing of solidarity are very top-down, right? So we see the European Commission assigning budgets, making legislation on certain points, which of course, should be an expression of the will of the member states and, the European people, etc. But we don't see at the moment still parallel processes in a more bottom-up way that actually create this sort of basis among people for solidarity and trust. And I think there's an issue of trust sort of at the basic level, but also there's an issue of trust, of course, between local and national governments and the European Union. And I think here there's a really interesting potential role for law, because I think the law could create more situations that would stimulate interactions that create additional trust. So, of course, there are beautiful examples of people coming together to, in solidarity to deal with some of these challenges that we're seeing. But if we look at the European process as a whole, we don't see as much dialogue perhaps between those on the ground activities and the things that I've just shown you in terms of the big funding strategies, the big legislative programs to actually foster more of that trust. So sorry, I know that was a little bit of a long answer to your question, but I just wanted to set out some of the key points in this area.
Thank you very much. And I propose actually to have all speakers, all interventions, and then we will have a time for questions, comments. And now I would like to ask John Morrison. And my question will be about sanctions. Sanctions work well if they are based on solidarity approach. But is it possible that actually sanctions doesn't meet human rights-based approach?
Thank you, Olena, and thank you. Congratulations to all of you involved in the Kyiv Forum. It's an honor to join you today. before I answer that question, which I think is, for me, a question about social solidarity to people on the one hand and fidelity to international law on another, and whether those things align most of the time, but are they in some level of conflict or not? I just want to sort of say, when I talk to businesses, and often at board level nowadays, they are asking this question the whole time because they feel, many of them, that they want to take acts of solidarity in relation to Ukraine, but also other places around the world. But there's a lack of guidance and toolkits and certainty to help them to take the right steps. And I think when I have conversations with them, including at the World Economic Forum earlier this year with the Deputy Prime Minister of Ukraine, sort of three buckets emerge. I mean, I think that first bucket is the corporate responsibility to respect, and we've already heard about from Professor Spano about the UN Guiding Principles on Business and Human Rights, cause, contribution, direct linkage, and the growth of mandatory human rights due diligence. That's clearly understanding your relationship to the harm as a business has to be the first step. But I would go a little wider than UNGPs. Ukraine reminds us that humanitarian law in relation to areas of conflict or also occupied territories, business also has to be very conscious of non-complicity and also providing essential services, if you like, within the theatre of conflict. The second bucket, and Olena, this relates to your work, I think, as well, is sort of the area of emerging norms to guide corporates in relation, and this brings us into the area of sanctions and boycotts to some extent. So many sanction regimes have carve-outs for so-called essential services. And I think that, in the context of Ukraine, we're wanting business to lean in terms of the provision of those services. And in other parts of the world, including Russia, there are efforts to get business to lean out, to leave, even if they are providing essential services. One of the big problems we have, of course, is no international definition as to what essential services are and aren't. The WHO has worked on that in relation to health. The US government itself, that probably has the most sophisticated sanctions regime through time, is inconsistent itself in terms of how it has applied that to Iran, Venezuela, Cuba, and elsewhere. Interestingly, the European Convention on Human Rights, and Professor Spano sort of touched on this as well, I think is, if you think about although it is focused very much on state duties, those sort of state-like roles that business often play in the provision of those state duties is becoming, I think, one of the baselines for companies. But of course, the European Convention on Human Rights is just mainly civil and political rights. So it doesn't really help us with those questions around food and health, unless it's a right to life issue. And then the final bucket is this issue of, I would say, the sort of discretionary solidarity, where the moral action, the ethical action that business should take. And here this brings us into this issue of boycotting certain markets, withdrawing from markets, providing humanitarian assistance, other forms of philanthropy. And it brings a business into what some people would call the arena of economic warfare, where there are no rules, I'm afraid, from a human rights perspective, very few other than the ones I've mentioned already. And I think to conclude really and come to your question is, I do think businesses, board level businesses, do feel there's some level of conflict there. And two of the issues that come up most of all, one is this issue of essentiality. I think we would all be better served by some better international definition of what really is essential in relation to food, health, energy, and other essential services. Because at the moment, the boardrooms of companies are interpreting that in very different ways in the context of Russia, but also the context of other places. But I think another term is this issue of consistency. Companies are aware that what the decisions they make vis-a-vis particular markets will be held up the next time there is another similar context, and pressure from consumers and civil society and politicians will come again. And so how do we get to a place of greater consistency as well as clarity around essentiality? And one of the tensions, I think, is this issue of human rights law versus human rights impact. And if I take the example of Myanmar, where we have a center, although our director is in prison at the moment there, Vicky would always say, you know, it's clearly now incredibly difficult to operate as an international company in Myanmar, but perhaps just possible if you're very sure where the red lines are. But in terms of the impact on people, and you take the 400,000 women in the apparel sector in Myanmar, those jobs will go when all the final Western companies leave. And those 400,000 women will probably have to be smuggled or trafficked to Malaysia to work in apparel, the way that they were 10 years ago. So then you have the sort of the human rights impact of withdrawal, according to international human rights norms, might not align law and impact around human rights. And I don't think we talk enough about human rights impact in the context of business and human rights. So I would definitely defend the right of boards of companies and individuals to join boycott campaigns. It's an issue of freedom of expression at the end of the day. Boycotts are important, but I do think when we move beyond the targeted sanctions like the Magnitsky Act, which are much clearly cut in human rights terms, there is this discussion around broad-based sanctions and boycotts. And I do think, Olena, your work on essentiality is really a very important part of that. But I think we also need to look at developing norms for greater consistency as well. So I'll stop there. Thank you.
Thank you. Thank you very much, John. And I hope that we will back to some of these issues during the discussion. And now I would like to give the floor to Professor Markus Krajewski. And actually, we have the link between what was said by John Morrison the work of Professor Markus Krajewski related to services of general interest and actually how European legal order regulates the services of general interest and what is the role of public enterprises to provide these services in the context of solidarity. Professor Krajewski, please, the floor is yours.
Thank you very much. Good morning to everyone. Thank you, Olena, for inviting me, and thank you to the organizers and sponsors. And can I start with a small confession? I have to say that ever since, for the first time, I saw pictures of the Kharkiv Forum and the Business and Human Rights Roundtable, I was secretly hoping that one day I would be invited too. And I just hope that being invited to this virtual forum doesn't forfeit the right to also come to Kharkiv one day in presence, because of course I would very much like to do that and see all of you, of course, also in presence as well. So, and thank you also for letting me basically go back to a previous part of my academic life in which I did indeed research on the concept of services of general interest, or as the treaty have it, services of general economic interest in EU law. And I think it's important because as you rightly state in the paper for the conference, Ukraine is now an EU candidate country. And of course, many issues that of course many colleagues in the room know, the Ukrainian legal system will have to adapt to EU law in order to accede to the EU. And so this is why I think it's quite interesting and important to also look at the link between the business and human rights issues and the EU law issues. So the term services of general interest or services of general economic interest is actually a term which has been in the treaties since the Treaty of Rome, so basically since 1957. And it's important to understand that the EU, of course, started as an economic community based on freedom of free market, free movement in the internal market, and of course, undistorted competition. So the idea here was to have an exception for certain companies which are entrusted, as the treaty has it, with the operation of services of general economic interest from the rules of competition law. And the European Court of Justice defines the term service of general economic interest very similar to member states' concepts of public services or public utilities in the British system, service public, in the French system, Daseinsvorsorge in the German system, but also very similar to, I think, the notion that John mentioned, essential services. So there are, of course, always, as when lawyers start talking, there are always debates about definitions, but I think we can say, generally speaking, this is what the treaty means. Now, what's interesting is these services of general interest can be supplied by private companies and public companies alike. And the idea is that these companies have, as the court would say, a universal service or public service obligation. And we're talking about energy, we're talking about transportation, postal communication, health, and social services. And really, the idea is these are these are companies which are services which would not be provided by a free market. And so therefore, there are some rules of competition law which should not apply to these companies. Now, the term then travels, the concept then travels, and it reappears in the European Union legal order in the Treaty of Amsterdam, and which is now Article 14 of the Treaty on the Function of the European Union, where for the first time the idea comes up that these services of general economic interest are a shared value of the European Union. So from an exception rule to competition, rules, it becomes, in the beginning of the treaty, a shared value of the Union, and it also talks about the role of these services in promoting social and territorial cohesion. So I guess this is already sort of a link to this idea of solidarity within a national economy, but also within territory, but also within the European Union. And then in the early 1990s and 2000, the Commission actually develops this new idea of services of general interest. I'm not going to go into the details here, but it's very clear that this is already where the link to solidarity comes from. And then there's a third sort of goal or third voyage of the concept, and that's when it's linked to fundamental and human rights. And we have in the Charter of Fundamental Rights of the European Union, we have Article 36, which talks about access to services of general economic interest. And it's not a full human right or not a full fundamental right, but it's very clear that the Charter links this idea of access to these rights, access to these services, to the ideas of human rights, in particular to the right to social security and the right to health. So, and I think that's interesting because this is part, actually, Article 36 is part of Title 4 of the Charter, which is labeled Solidarity. So the Charter, and this is maybe there's an interesting difference to what we heard from Judge Spano this morning. The Charter actually, when it talks about solidarity, doesn't put an emphasis on duties, but rather puts an emphasis on economic, social, cultural rights, and puts sort of access to these services, essential services, in the context of economic, social, cultural rights. And of course, in human rights language, I would say this idea of entrusting companies with services of general interest with the public service obligation is an exercise of the state duty to protect. So what does this lead us for solidarity, which is, of course, the topic of our discussion? I think it's very clear that at least in the EU legal order, solidarity is linked to basic and human rights, but as I said, not necessarily to the idea of duties, but rather to the idea of economic, social, cultural rights. And maybe we can say this is sort of a different pillar, if you wish, a different human rights pillar of human rights, of solidarity, I'm sorry. The next point, which I think is interesting, is that it's very clear that those who provide these services can be the state, can be public enterprises, but often can also be private enterprises, but with a clear mandate, with a clear legal or administrative obligation to provide these services. So the idea of services of general interest actually brings the responsibilities of companies and the obligations of states together. And I think this is actually something which also we could explore further for the business and human rights debate. Many of you know, of course, that guiding principle 4, which addresses enterprises owned and controlled by the state or receive substantial support or services from state agencies, in the context of state-business nexus has a rather, I don't want to call it narrow, but maybe just a more limited perspective on the relationship between state and corporate actors. And I think we should think about that should also include enterprises which are entrusted with these public service obligations, because that's one way of actually realizing solidarity in a human rights context. Thank you very much.
Thank you very much, Professor Krajewski. And actually, I during all this time, I had the secret dream to have you in the Kharkiv Forum. So it's really great that dreams come true. And now I give the floor to Professor Tatiana Komarova, and actually I would like to ask her about the role of solidarity for Ukraine, and is Ukraine ready to implement solidarity approach, how it's indicated in European legal order?
Thank you, dear Lena. If you don't mind, I will speak in Ukrainian because our audience is mostly Ukrainian speaking.
So I'd like to shift the focus a little bit and to present the solidarity principle from the point of view of the public dimension in the EU, because before that we spoke about private dimension, vertical and horizontal, but I'd like to focus on how the solidarity principle is interpreted in the EU and whether it has soft power or maybe it is already binding for EU member states. So let me start by saying that the solidarity principle is considered to be the constitutional principle in the EU because it is stipulated in the foundational law of the EU, and it is actually constitutional by nature because there are a lot of features that are characteristic of national constitutions. I'm speaking about the Treaty on the Functioning of the EU Treaty, and the Charter on Foundational Rights. So the solidarity principle has always been important politically for the EU because it is actually the embodiment of the idea of Europeization, European integration. Founding fathers of the EU, they actually emphasize that. For example, in May, in the Declaration on the European Treaty, it was stated that Europe will not be established, created at once, according to just one plan. That will be the process building on certain activities and steps that are de facto aimed at creating solidarity. So this is actually about creating the common market, which is the idea of Europe. This is the principle that contributes to development of the four freedoms of the EU, the commodities, services, capital, and labor force. That's why that principle was included into the statutory treaties of the EU. Now, there are several areas where the solidarity principle definitely applies. Migration, energy, counteracting terrorist attacks and natural disasters, and the common foreign policy and security policy. However, at the beginning, the solidarity principle was stipulated in the treaties as the goal. In the EU, it was supported as a voluntary support for each other in case of crisis. And actually, to that, the EU contributed, because the EU adopted a range of resolutions, regulatory documents, that where solidarity was stipulated as a foundational value for international relations, but the form of stipulation of the solidarity principle for the EU, for General Assembly, was always soft. And that is why that was perceived by the states and by private entities, actors, as a voluntaristic goodwill of the states to comply with those solidarity requirements. However, recently in the EU, this principle has started becoming very tangible, practical, in particular via the practice of the EU Court of Justice, and the case law of the EU Court interprets the law, and there is so actually they say that EU law is compliant with the statements of the court. So currently they have started expanding the principle of solidarity starting after 2000 and especially after 2009, where the democratization process in the EU activated. About 30% of cases of the EU Court of Justice are focused on horizontal solidarity. So I'd like to suggest for your consideration 2 cases of the Court of Justice of the EU that clearly address this issue, where the solidarity principle is no longer the goal, but a concrete obligation of member states, where they must act respectively in the 4 main areas which I have mentioned already. And let me start with a case on migration. This is 2015. Slovakia and Hungary versus the EU Council against their decision on the movement of migrants from Italy and Greece. This is about quotas of migrants for all EU member states, not just placing them in Italy and Greece where refugees arrive. So the resolution of the EU Council stipulated that all the states need to undercare the burden of that migration impact of migration flow. Slovakia, Hungary, Poland, Czech Republic, Visegrad countries, they were categorically against that decision of the EU Council. They emphasized that they interpret the solidarity principle as a kind of goodwill, as a voluntary thing. However, the EU Court clearly stated that the principle in the field of migration policy is the source of rigid or hard obligations for member states. Moreover, this principle must and can be enforced by courts and protected by courts in the EU. However, the court sets the criteria when this principle becomes binding. The court stated that since the decision of the Council on migration is a concrete expression of the solidarity principle, it entails legal obligations. So it is when it transforms into a specific legally binding obligation through the process of adoption of specific activities according to EU legislative procedures. That means that member states have legal obligation to act for the benefit of other EU member states, even if that goes counter to interests of this particular country. And actually, this is confirmation of the position of the EU law and the core statement that the state cannot violate EU rules in order to protect national interests. So actually, this decision put an end to this voluntary application of solidarity principle in the EU, though we could refer to EU directive on temporary protection, which was adopted back in 2001, but started being implemented after the aggression of the Russian Federation, when Ukrainian refugees started arriving to the EU. Actually, before that, there were no cases of precedents of active application of that. So there, unfortunately, the states clearly state, even though this is a legal act, but there the states do stipulate that the solidarity principle can only be applied voluntarily. So there is this caveat. The second case that I'd like to mention for solidarity principle is about energy sector. This is very relevant for Ukraine, for Ukrainian interests in the energy sector. So energy solidarity turns out to be a Pandora box for the European Union. The EU Court decision of 2019 was about that Ukraine protested against the decision of the EU Commission on Nord Stream 1 expanding the capacity of that pipeline. Unfortunately, that was rejected because Ukraine was seen as anti-plaintiff, but Poland also submitted the respective motion, and based on that, the Commission did not take into account the principle of energy solidarity. It failed to involve all stakeholders to the decision making, and also didn't make sure that this didn't take into account that the impact will be on Poland, because actually the gas pipelines will be refocused, will go in a different direction. So the court agreed that this principle implies general obligations of the EU and the EU member states to take interests of all the stakeholders that may be affected when a certain decision is made. The EU court went even further. They said that even though in the energy directive of the EU it is not stipulated that solidarity principle must be respected, but the very fact that it is indicated in the constitutional treaty on energy, and this is a sufficient ground to make sure that any energy-related EU decisions were in line with the energy solidarity principle. And that means that the energy sector in the EU, which is part of the security sector now actually, is absolutely covered by the solidarity principle, and no decision of any public stakeholder can be made without taking into account interests of other stakeholders. And actually that's a very hard, rigid statement of the EU court, where we see that the solidarity principle is an obligation, is binding. In the context of your question, Olena, if Ukraine is ready to undertake obligations under solidarity principle after EU membership, well, you know, I don't have a clear answer to that, because it is something to be further reflected on. And I am sure that none of us have the answer to that question. I mean, and as for further reflections, I believe that we will have a further discussion on that. But definitely the solidarity principle is a challenge, not only a bonus for EU member states and for the EU in general, because retrospectively the EU Commission, European Commission is now obliged to comply with the solidarity principle. That's a fact now. This is my short message on the solidarity principle and how it is linked with the EU and future membership of Ukraine.
Thank you. Дякую дуже. Thank you very much. And actually, we see that solidarity is very cross-cutting, cross-cutting principle, and has multi-dimensional perspective. And I would like to ask Olga Boyko actually about understanding of solidarity by business actors in Ukraine, and actually what challenges for understanding of solidarity by businesses in Ukraine during the war.
Thank you, Elena. Good morning to everyone, and I'm very happy to be present here today and to share our experience. I would rather say that we will slightly shift from more theoretic part to practical part, because as you know, everything, every law, every legislation and regulation has to be implemented, and usually it is business and corporations that reveal some insights or positive or negative sides from this point of view. And really, Russia's full-scale invasion of Ukraine shook the usual global order, and but it did not force businesses to abandon their social responsibility commitment. And since the first days of war, as we can see from our member companies, Ukrainian business has been proving itself in all ways possible. It has consolidated and focused on aiding the state and the people. And it was our honor this year to have our second EBA Sustainability Index survey. We have just finished it. And though the results are not available yet, I would be happy to share with you some trends and some observations we get from the previous first phase analysis. If we see, if we speak about companies' current priorities, if last year it was more focused on decarbonization, on environmental issues, now it's totally different. The current priorities for our companies in Ukraine are healthcare and safety of staff and people living in cities and towns under risk. I mean, our southern and eastern regions, and especially an aid to internally displaced people. Businesses also heavily support healthcare facilities and keep contributing to maintaining the country's stability. They pay the required taxes and fees even in advance, and they provide workplace for people who were obliged to leave their house. And the army support is the second priority for companies. And there I would like to put attention of that earlier in the previous years we were talking about that military support cannot be treated as one of the ESG priorities that could be that could have possible impact on companies' reputation as a sustainable business. But for us in Ukraine, everything changes 7 months ago. And one more thing is that city formal enterprises, in some cases, substitute local authorities providing humanitarian aid to community. Especially it worked for regions that were under attack in the first days, and it was companies, it was corporations that provided shelters, meals, and first aid kits for people in these territories. Second insight is about reporting. As we know, a company try to respect their commitment and publish their non-financial reports, even in these difficult times. And we see more and more reports that are open for the company's results of previous year, but moreover, the information concerning the war impact is included in these reports for the last year results. And to my mind, it shows a higher level of perception and maybe understanding of what the sustainability truly means for business. It is not about only talking and trying to convince potential investors and stakeholders on the positive impact of the company, but also how this whole situation influence and on the company's health. Third insight is about respect of sustainable development goals. If in 2021 business sector was not very impressed with the efforts of the government in implementing of the SDGs, and it was like more like a little criticism, I would rather say, then this year we might see a very different picture. And companies rated its efforts, government's efforts, I mean, as middle and even close to positive, to good level, while last year it was rather negative analysis. And of course, social component is the most integrated into government policy of martial law and of post-war recovery, which we can see in our draft plan of national recovery after the war ends. Fourth observation is about some lack of attention to previously vulnerable categories of people, such as disabled people or elderly people, as well as orphans, that were slightly moved back. By the way, what I told at the beginning of my speech, that environmental and climate projects were among top priorities last year, and now it is considered mostly like strategic steps, especially for energy-intensive industry such as steel, energy, and agriculture. And this is a great reference from to the previous speakers that told that the solidarity has another level and another field of impact now. Next point is that company, to my mind and what I see now, don't feel like competitors anymore. They form some kind of communities and try to work together, providing our victory. By the way, we haven't seen it during COVID-19, and it means that Ukraine probably has renewed its national idea, and that can now really unite people and serve as a basis for cooperation of the government and corporation. And from our side, as a business association, we rather try to play a role of soft power and provide some kind of risk assessment for our companies, especially when we are talking about companies that make business that are still present in Russia, and let's have partners among Russian corporations or among corporations that are related to Russians or companies or sanctioned people. We try to explain what can be the impact on their reputation and what would be the best way to avoid negative consequences. And answering to your question, Elena, I would say that despite all this critical situation, companies go on adapting to the European Union new regulation, especially in due diligence, such as in new directive on social responsibility, and new regulation on deforestation-free products, and etc. They are trying to adapt their policies, and they're building the teams and hiring people to get ready for this. And speaking on solidarity, I guess we should remember that we don't live in the vacuum that was told by our first speaker. And if we want to achieve our goal in decarbonization and in human rights respect, we need to create maybe new inclusive rules. And instead of trying to create some kind of obstacles, non-economic trade barriers, European Union and Ukraine, as its integrated part, should protect European values that are justice, transparency, and cooperation. Thank you very much.
Thank you to all our panelists. And I don't see at the moment questions in our chat, so I would like to start to ask you. So I would be the first. What do you think when we are talking about a time of war or other public emergencies? We are talking about possible for state to derogate from their human rights obligations, of some human rights obligations. But it seems that businesses in opposite way, in times of war or other emergencies, they have more obligations, more human rights obligations. Do you see that it's something unlogical, because if we are considering states and businesses as human rights duty barriers, should actually the same rules be applied for duty barriers? Or maybe my vision of this tendency is wrong. So please, please, I would be glad to hear your comment.
I'm probably the least qualified to answer this question, but maybe just a brief reflection on what I think what we've seen a lot of across most areas of public of the public sector. I think your question to me really links the questions of delegation and the fact that so many public powers have now been delegated to private entities. And I think in those circumstances where private actors are actually acting under a public mandate, I don't think that this division can be rightfully maintained. And I'm sure Marcus has many more sophisticated insights on this. But I think actually in other cases, I do think that can be justified by the fact that for whatever powers that companies hold, which I think now they're really expensive, they don't have the police powers of the state, So I think in these kind of, especially situations of public emergency and conflict, I think, of course, some of the powers of the state to use force to enforce certain things is not the same for companies. So I think that's a very brief, reflection on that. But I would like to give the floor to Marcus.
Thank you, Marcus, please.
Thank you very much. I think it's an extremely interesting question, and it really made me think. And I'm not entirely sure whether I would share the empirical basis of your question, if you wish. Of course, we do have the right for states to derogate from human rights obligations in times of war and emergencies. But I mean, now Judge Spano has left us, but I'm sure there are colleagues in the room who can speak to this more adequately. But it seems to me, at least, that this right to derogate is becoming more and more an arcane right. And a lot of issues are now actually being discussed in the context also of justifications, of limitations of human rights. And at the same time, I mean, businesses also have the possibility to derogate from their contracts under force majeure clauses in times of war. So I'm not entirely sure whether we really can say in times of war, the state sort of doesn't have obligations anymore and businesses have more obligations. They shift. I mean, we heard about humanitarian law. I mean, in times of war, states have obligations under humanitarian law. So I think what we're really looking at are different obligations which shift, which adapt to the situations. But I'm not sure whether we can really say, I'd like to hear you maybe, Olena, on why you think there is sort of less obligations on states and more obligations on businesses in times of war. But I would also join with Josephine that, of course, we should also maybe, and this is also, I believe, what Olga also said is maybe we should, or Tatiana, I think it was, we should move away from this is the state, this is public, this is businesses, this is private, because we see so many more merging areas there, and we really should talk about sort of essential obligations and essential rights.
Yeah, thank you very much, Olga. Am I right when I'm talking that businesses actually have more obligations during these difficult times related to human rights, or it's just my subjective feeling?
Yes, Elena, I was actually looking for the sign to raise hand because I also wanted to be involved in the discussion. Really, I would like to remember that, it was 2 years ago that Edelman Trust Barometer showed that people has more trust to companies than to state authorities. And it means that in this vulnerable time, even companies are more important and more powerful for people, to my mind, that the state. Just a really brief example is about from environmental field. For example, the environmental assessment procedure, environmental impact assessment procedure that we have in our country as well as in the European Union. One of the part of this procedure is related to the research made in the field. For example, to find out what kind of plants of animals live in the area where the company want to make its activity, and what kind of impact it could have on the nature. To make this research, company usually send to the field their own employees, or they can work with partners. But now, if we see our territories, we cannot say that it is quite a secure kind of doing business. Why? Because we have a lot of territories that was under occupation, that was close to the hostilities, to the active hostilities, and that was not without access, let's say. And but our current law on environmental impact assessment does not provide some exemption for martial law, and that's why companies are trying to launch these changes, because they want simply to protect their employees and their human resources, because as you know, from one side it's their responsibility for their teams, and from the other side it's about our other legislation base that is related that each accident that happened during the working hours of each employee is the company's responsibility. So here we have both sides of the coin, and I guess that the corporate sector is more has more quick responses on the risks and on the critical situation we can have if we talk about human rights and the possible derogation of human rights in the public and in private sector. That's what I think.
Thank you very much, Olga. And I also see that John would like to add, please.
Yes, Elena, I won't talk about the derogation aspect of it. Others are much better qualified than me, but I will talk about the increased obligations on corporations. I mean, I think de facto, under humanitarian law on the ground, when it comes to access to food, water, shelter, in many humanitarian crises, de facto, that is the case, because corporate facilities cannot be withheld from starving populations or populations in need. And we see this in terms of whether it be in Haiti, in terms of hurricanes or flooding or environmental disasters, but also war and conflict too. De jure, okay, which is the legal part of it. I think one area that's interesting, and I think the previous speaker mentioned this issue of less competition between business. So I do think in the context of big challenges like in Ukraine, but also environmental challenges and COVID as well, is we saw a growth of what you could call pre-competitive space, where competitors within industry and also in government and others were making decisions quickly, and there was some suspension in some countries of competition law, and special arrangements were made around public procurement. Now, I think we're going to see more and more of that. There's a danger, of course, because that was abused. Certainly in my country, the UK, the tendering arrangements under COVID were abused, and there was corruption that came in quickly there. And that's subject of legal challenge at the moment. So you've got to be careful when you sort of rejig competition law and others But I do think there's a trend there, definitely. And whether that ever gets reflected in the law more generally, I don't know. But thank you.
Thank you very much. Olga, we also have a question for you in the chat. Maybe you can provide some links or examples in the chat as well. Thank you very much. Actually, to be honest, this question came to my mind just during our discussion, so I don't have actually the answer to this question that I was asked. My reflections are just about that we have two different dimensions of this question, internal and external, and when we're talking about derogations by the states, we are talking about international obligations to follow some standards, to follow some procedures. When we're talking about obligations of businesses in times of war or other global emergencies, we are mostly talking about expectations from the field, and assessment of the human rights risk. Human rights risks are increased, and that's why human rights obligations of companies increase as well. No, but it's just my first reflections after our discussion, and I would be glad if we maybe some of these thoughts can be based for our further discussions as well. And I would like to thank all of you, all our panelists of the first session. And we are opening our next session, second session, and this session will be actually about solidarity and corporate respect for human rights. And our panelists for this session, Professor Florian Wettstein, Professor of Business Ethics and Director of the Institute for Business Ethics at the University of St. Gallen in Switzerland, Dr. Nadia Bernas, Associate Professor in the Law Group at Wageningen University, Professor Jernej Letner-Černič, Full Professor of Human Rights and Constitutional Law at the European Faculty of Law at the Faculty of Government and European Studies of the New University, and Beata Faracic, internationally recognized human rights and business expert leading the Polish Institute for Human Rights and Business. And actually, my questions for all our panelists are about actually possible conflict between solidarity and individual human rights, and could we expect from corporate actors that they can balance solidarity, some community interests, and individual human rights? And do we have actually legal dimension of corporate responsibility to respect solidarity, or it's mostly ethical request, ethical dimension of corporate responsibility to respect solidarity? So please share with us your thoughts, and I would like to give the floor to Florian.
Yes, thank you, Elena, and thank you for having us, even if in this virtual space. And I would second Marcus's statement before that we would, of course, all like to be there in presence much more. But as a second best, I think this is a wonderful platform and well attended, and it's really a great pleasure to be part of this. So thank you very much for having me. Now, you asked if there's a conflict between, or a potential conflict between, solidarity and human rights. And I want to frame it slightly differently, between solidarity and what we commonly accept as the responsibility of corporate actors in terms of human rights, which is the responsibility to respect human rights, right? And I see more as a kind of a complementary relationship. And I'm talking here and approaching it here from the perspective of an ethicist and not necessarily of a lawyer. And so I see this more as a complementary relationship. Insofar as I think both of those concepts have certain limitations that the other ones might potentially be able to kind of fill in that sense. The obvious limitation of the responsibility to respect human rights, at least as it is framed commonly in the business and human rights discussion and in the guiding principles, and I've been writing about this before, is of course that it's limited to kind of a negative outlook and responsibility, meaning it's framed as a do no harm responsibility, which corporate actors but also other individuals and so on have. And of course that can be contested and disputed, that that's the only responsibility that corporate actors should be having, especially if we talk about those specific contexts like conflict and so on, as we did before. And I think there the solidarity concept goes distinctly beyond, of course, a responsibility to do no harm. In fact, I think it is, from an ethical point of view at least, defined by kind of the positive outlook on responsibility, the responsibility to come to someone's aid and to help someone who is in acute distress, for example. So there's the kind of the complementary relationship on the one side. Then solidarity, on the other hand, I think has critical limitations as well, insofar as I see it hinge on kind of a shared, call it identity, or a sense of we. So it's limited in its scope. Also because I see solidarity more as kind of hinging on a moral sentiment, in a sense. So this identification with the other and the identification with a certain community, be it political or else, that really delimits the reach and the scope of solidarity. And I think that's not the case for a responsibility to respect human rights, which is, if you will, based on kind of the idea of justice, which by definition is not limited by kind of a sense of or a moral sense or a moral sentiment. And as such, I think the responsibility to respect can make up for this kind of limitation of scope of solidarity. And so therefore, I think it's not a conflict, but I think what the challenge is to bring those two things together. And as I have argued before, I think the responsibility of corporate actors can and should not be limited to merely a duty or a responsibility to do no harm. I think there's weighty reasons for why corporate actors have responsibilities that go beyond this. And I think that is where solidarity really can come in as a helpful and useful concept, not so much necessarily in terms of providing an argument for why those responsibilities should go beyond do no harm, but to provide maybe a moral motivation to do so. I think solidarity, first and foremost, from an ethical point of view, can be a driver of corporations, maybe that change of mindset that also Judge Spano addressed, right? So if we want corporations to become more proactive in addressing their human rights responsibilities, and I do see solidarity not as something that is kind of different from human rights obligations. I think solidarity itself can be framed in terms of human rights as well, and fulfilling and realizing and protecting human rights. And I think the concept of solidarity can provide this driver for corporations to address those responsibilities, not least because I think solidarity is something that can be, call it, trained. I think solidarity can be built. It can grow over time. As we build communities, we also build solidarity. And I think that is where we need to maybe latch on to in that sense. So the question is, how do we build solidarity among corporate actors within specific communities and situations to really address those responsibilities and go beyond merely respecting human rights. So I leave it at that, just with this brief general conceptual relationships, and then we can discuss more specifically afterwards. Thank you.
Yeah, thank you very much. And Nadia, what do you think from legal perspective?
Hey, can you hear me?
Yeah.
Okay, great. Now it's working. Thank you. Thank you so much for the invitation to speak, Elena. It really is a pleasure to participate to the Kharkiv Forum this year again, despite the circumstances. And I'm really grateful for the opportunity to discuss these important questions around solidarity, corporate actors, and human rights in such great company this morning. So let me start by saying that solidarity is an underexplored theme in the business and human rights community. Perhaps we can say that solidarity is such an important concept that it is implicit in many debates in our community. And I will talk about this a little bit, but the fact remains that solidarity is not a concept usually discussed or routinely discussed in business and human rights. So to prepare for this talk, I searched the 5 business and human rights international instruments that have been developed over the years, some successfully, some unsuccessfully. So in chronological order, I looked at the OECD guidelines for multinational enterprises, the draft UN Code of Conduct for transnational corporations, the 2003 draft UN norms, the UN guiding principles, and the 2021 draft treaty on business and human rights. And none of these instruments even mention the term solidarity. So I did my control find search, and I was actually really surprised about this, that not even in sort of introductory remarks to these texts, or not even anywhere, I found the term solidarity. So I think I'm pretty solid when I say that it's not a theme that is usually discussed in our community. So what I want to argue in 5 minutes is that we can, in fact, read solidarity into the existing business and human rights framework, and for 2 reasons. So one reason is close to what Florian has just argued, which is the formulation of the UN guiding principles themselves, so the text. And the second reason for me has to do with the polycentric governance origins of the UN guiding principles, so the architecture of this instrument. So let me start with the text of the UN guiding principles. So as we know, within the UN guiding principles, the corporate responsibility to respect human rights is phrased as a social expectation, what society or societies expect of good businesses. But then immediately, Pillar 2 of the guiding principles moves to corporate due diligence, which I know will be discussed in the next panel. But I can already say now that Pillar 2 asks companies to set up due diligence processes, which are essentially a risk-based management process. So we asked companies to look how and when and where they may impact human rights, and to act accordingly to avoid that. So this risk approach has the advantage, I think, to be relatively clear. But I have been thinking for a while now that the success of the due diligence concept, I mean success because we now have it in legislation, we have it in a draft EU directive. I mean, it has really taken off, I think, as a concept. But the success of the due diligence concept, in my view, has somehow limited our understanding of the corporate responsibility to respect human rights. In short, I want to argue that there is more to business and human rights than due diligence. So the words for me have meaning. The term responsibility, even used in a non-legal way in the UN guiding principles, and perhaps even also to echo what Florian was saying, perhaps because it is used in a non-legal way, is a powerful word. It's not just do no harm or avoid impacts. The term responsibility connects to broader concepts such as corporate citizenship, corporate social responsibility, and not corporate social responsibility in the sense of funding philanthropic projects, as unfortunately it has come to mean for some people, but in the sense of behaving like good and decent organizations. So to me, the corporate responsibility to respect necessarily encompasses wider and powerful ideas such as dignity and solidarity, which perhaps today I fear are lost in more technical discussions about human rights due diligence and contractual assurances and first tier of suppliers and second tier of suppliers, etc. Where is the responsibility in that? For me, it has to mean something more than these technical issues. So that's my first point, that corporate responsibility to respect human rights, to me, is broader than due diligence. And in that sense, solidarity can and perhaps should inform our understanding of Pillar 2. And secondly, and this is a little bit more out there, but I want to propose the idea that the polycentric governance architecture of the UNGPs, and particularly the articulation between Pillar 1 and Pillar 2, implicitly embraces a wider understanding of the term responsibility, corporate responsibility. Why am I saying this? Because Pillar 1 and Pillar 2 are built so that they can be independent of each other. So that in any situation, even when the state is weak, for whatever reason, it being just a situation that happens, or the rule of law is not prevalent in the country, or maybe there is a war, or maybe something else, that there is, irrespective of how the state behaves, there is this standalone corporate responsibility. And to me, this is one of the most important achievements of the UNGPs, to have disconnected these questions of state and corporate responsibility. So it doesn't matter where you are, as a company, you have this standalone responsibility. And I think naturally with this architecture, this responsibility cannot end with a risk-based approach, with this narrow risk-based approach, because especially in areas of weak governance, naturally companies will come to play a more important societal role. And I think you and I have discussed before how Uber played a role during the early days, at least, of the conflict, of the invasion of Ukraine, by basically transporting people to safety through the app, etc. And this is way beyond, I think, a risk-based approach or anything like this. So this standalone pillar, in my view, is an invitation to see corporate responsibility as broader in times of crisis and informed by concepts such as solidarity that can guide corporate action. So I will leave it at that and look forward to the discussion. Thank you.
Thank you. Thank you very much, Nadia. Yes, thank you very much. And during the first session, we discussed a lot about actually social and economical rights in the context of solidarity. And I would like to ask Jernej Letner-Chernich about actually this solidarity dimension of corporate responsibility to respect economical and social rights. And actually, do companies have a duty to protection and to fulfill or just to respect in this context?
Thank you very much, Olena. Good to see all of you, my colleagues and friends. Thank you, Olena, for keeping the Kharkiv Forum alive and kicking even in the middle of aggression. It's not easy, but nonetheless, it's an honor to give this short presentation. Yes, the connection between solidarity and individual rights is mutually reinforcing. At least in my opinion, solidarity has always been considered as one of the core values of human rights law, together with freedom, tolerance, pluralism, dignity. And particularly, as you asked, Olena, solidarity is a value which reinforces socio-economic rights. Those rights which enable individuals to have access to water, to housing, to food, to basic education, to basic health. And it's true, as Nadia mentioned, that this area of business solidarity and socio-economic rights has not been fully explored in academia, but also in practice, even though there are many examples of how businesses have in the last decades, but even now in the last couple of months affected socio-economic rights. We can just remember of an environmental disaster caused by BHP Billiton in Samaraco in Brazil, which upset the socio-economic livelihoods of thousands of fishing families around the dam. Or we can also think about the activities of Nestle at coffee plantations in Brazil, which also affected socio-economic rights of population. And there are similar reports from Myanmar and Guatemala, but most recently, since February of this year, there have been many examples how companies, mostly state-owned companies in Russian federations, have affected the enjoyment of socio-economic rights and will affect their enjoyment in the next couple of months in the whole of Europe, given the increasing prices of gas, fuel, and other fossil fuels. So the evidence is there that there are corporate impacts on socio-economic livelihoods of individuals and also peoples around the world. As far normative connections between solidarity and socio-economic rights go, well, the relationship is a bit more complex. As many of you know, socio-economic rights have been in the past, after the Second World War, conceived as a separate group in comparison to civil and political rights. Mostly we say when we teach our students that socio-economic rights, they create obligations of conduct on the part of state. They're not obligation of result, at least not to the full extent. They mostly depend on available financial resources of state. We often question in our discussions in academia whether they're enforceable or not, whether they should be implemented immediately or only progressively, or whether the states or even corporations can undermine the level of their provision in the future. And we also are aware of the arguments that several UN committees, mostly UN Committee on Economic, Social, and Cultural Rights, has in its general comments reaffirmed that at least the core of socio-economic rights is enforceable, and that states have obligations to fulfill them, not only respect them, but also protect and fulfill them, not only to comply with negative obligations, but also to ensure positive obligation. Of course, another challenge in business human rights is whether businesses, as you asked, Olena, have positive obligations, whether they have obligation to protect and fulfill socio-economic rights. As I have argued in the past, there is evidence, mostly from domestic systems, that businesses have obligations to respect socio-economic rights. No, there are several case law from different jurisdictions in global South, but also in global North, where the courts reaffirmed obligations of businesses to respect social economic rights, mostly in the context of state-owned enterprises. When the public companies, state-owned enterprises are involved in the provision of water, distribution of water, also housing and education. And also there is some evidence from international arbitration, from some cases that businesses have obligation to respect. There was a case against Donegal International a couple of years ago, where High Court in London ordered a hedge fund to repay the debt to the Republic of Zambia. Also, there's an example of a settlement between Anglo-American and Anglo-Gold concerning the failure to comply with safety and health regulations, which caused lifelong diseases of workers which used to work their mines in South Africa. So there is some evidence that obligations also extend to corporations, at least concerning this negative part. But surely states are primary holders under social economic rights. We have to recognize that. But nonetheless, I also have argued in the past that corporations, they play an important role in realizing economic and social rights of its employees and society as a whole. If you ask me, Olena, would I say that corporate obligations concerning socioeconomic rights extend also to obligation to protect and fulfill to positive obligations? I would argue that, at least in the context of state-owned companies, where the state has a majoritarian or a large share, then the state has obligation. State-owned company would have obligation also to protect social economic rights, just by the fact that the state-owned companies have to lead by example. They are extended arm of a state, and that has been also partially recognized by UNGPs in those principles which affect concern state-owned companies. And in the context of the recent aggression, also recent aggression, definitely the major corporate players, which nowadays they affect socioeconomic rights, both in Russia, in Ukraine, in the region, in most of Europe, are state-owned companies. As we are all aware, companies such as Gazprom, Rosneft, Nasneft, the Ukrainian state-owned company, and definitely those companies have obligations not only to respect but also protect socioeconomic rights, and thereby provide for and comply with the rule of law and their human rights obligations. Those companies are asked to lead by example. All of that to fulfill the aim what Amartya Sen and Marta Nussbaum always have been saying, that access to basic socioeconomic rights like water, housing, education, health is necessary in order for individual to realize herself, in order to implement herself in other areas of life. And definitely one can argue that businesses, particularly state-owned companies, Olena, have also obligations to protect and fulfill in relation to socioeconomic rights.
Thank you, dear Yevgeny. Maybe I don't agree with you in the part that it's about state-owned enterprises, because I think that we should focus on the functions. If companies provide the same functions as state-owned enterprises, for example, again, to provide access to essential goods and services, I don't think that we should actually to have this difference between state-owned and private companies. But yeah, but it's the point for the discussion. And I also would like to ask Beata Faracik. Actually, Beata, what do you think? For example, Polish companies which provided assistance and help for Ukrainian refugees. Actually, are these examples of corporate social responsibility or business and human rights and responsible business conduct? In the context of solidarity, it's interesting to consider these examples actually during our discussion.
Well, thank you very much, Elena, and well, thank you for inviting me again to speak at the forum. And it's just very strange to think that last year we could have discussed it in person, and just really hope that this will be the case next year as well. I think, well, basically when preparing for today, I just contacted a couple of companies and just asked them why they've done what they did. And kind of, I think it's perhaps just worth recalling that a number of companies in Poland kind of both helped, like if they had staff and operations in Ukraine, they helped with relocation at times, not only of their workers, but also families, sometimes like 200 plus people per company, and provided them for several months with basically accommodation and sustenance and so on, and assistance to settle in Poland. A number of companies have turned their office space or spaces that they had into accommodation space for refugees. A number helped with fundraising, contributing both in kind and financially. A number actually tried to gather, this is kind of what was being said about companies kind of working together, for example, to secure funding and purchase ambulances and bulletproof vests and sometimes even drones, which is another kind of interesting question, like, should they do it? Should they buy basically weapons for the war? But that's a bit on the side. But all the people that I've asked, so like all of them just basically stated, like, no, like for us, it wasn't a question, like, no, we haven't thought about human rights. Like for us, it was just ethical, moral imperative that we just need to do like this because we're all humans. And I think in Poland, it's also very specific because we also very, well, you know, freshly, it's a quite strange word perhaps in this context, but it's still very vivid in people, like in particularly older generations' minds, that on 17th of September 1939, Poland was attacked by Russia. So yes, we had Nazis on the 1st of September and then 17th of September, Russia. So we know what it is to have the imperialistic Russian mir being introduced onto your territory. So I think this also played into the very strong and emotional reaction of the whole society, but also companies. And at the same time, I think we really also need to highlight that, or at least stress that, unfortunately, that's not the case with all the refugees fleeing war. And it's very, very schizophrenic, actually, feeling when you look into Poland and how Poland, both at the state level and government level, and also companies level, kind of react to the situation that is happening on the border with Ukraine, where there is all support and warm welcome and everything, and the border with Belarus, where we have refugees from Syria, from other countries in the global south coming through Belarus. And we can leave the political reasons. I mean, obviously, there are some very strong political reasons for that. But we do see the number of pushbacks, and we don't see companies reacting strongly and condemning this practice. Those are very, very individual, very single situations when these pushbacks are condemned by companies. Rather, when the wall was being built along the Belarusian border, there was quite a strong competition for the work, for the public work, for the public procurement stuff that was being allocated there. But just coming back to the main point, I don't think really companies in Poland think of it in terms of, is it BHR or CSR? like for them, it was religious, ethical, moral imperative that they should act this way. Although in practice, it was indeed very often coordinated by people who were assigned to corporate social responsibility roles. I mean, if there would be human rights officers in the Polish companies, of which I'm not aware as for now of any single who would kind of have it as the full scope of work. It might have been also their task. So I think companies are just kind of looking at it. If they had to tag it somehow, they would probably say, yes, it's part of our CSR, it's part of our social responsibility. But I guess when you start talking to them, and this kind of starts to reflect when you go deeper into how they understand it. It starts to reflect what Nadia said, that yes, it's kind of like, okay, so now that you've told me what this BHR is about, yeah, it's kind of like, it is part of our responsibility. But it also takes a while for them to reflect that actually part of solidarity is not only providing assistance, but it's also being very diligent about their own operations and really doing this due diligence. Again, the terms that majority of them would never use in this context, but kind of looking into how they contribute to this war, if they do. Are they having any operations in Russia? Do they deal with any of the Russian companies? What they should do in this format? But what I found very interesting is that some of them kind of pointed to the fact that for them, it's very important to stay in touch with their either Ukrainian kind of business partners or subcontractors or suppliers, and just basically see if they can help them somehow to survive through this period of conflict, so that they kind of maintain some basic level of financial solvency, which I think is also very important, because if the company goes totally bankrupt because of all the affected economic and transport channels and kind of being able to actually continue your normal business operations. I mean, obviously a number of people who are working for those companies will be affected. So I just found this very interesting also kind of turn, and I would also see it on the solidarity basis. And I have impressions that this wouldn't be necessarily the case without the conflict. What I'm trying to say is that simply probably they wouldn't be caring so much about their suppliers and subcontractors in Ukraine, if not for war. Probably normally it would be just normal business rules applies. You can't deliver it. Well, okay, we are severing the cooperation. But here we can see that there is much more effort to cooperate and to find ways to support business partners in Ukraine. And, you know, when we're talking about human rights and business and solidarity, I mean, I did what Nadia did. So I've checked some of the documents. But then I've realized that for me, kind of like the first thing that comes to my mind is actually Universal Declaration for Human Rights. And yes, you can't really find their solidarity kind of in the ways that we are looking at it. But if we look at the Article 1 and the statement that, you know, everybody should act towards one another in the spirit of brotherhood. And in a way, for me, that's kind of also very strongly connected with the solidarity, because if we are to ensure that others' rights are respected, then we should do everything we can to actually help them to be materialized. Yeah, I guess that's pretty much. Sorry, I know that I went over the time, so apologies. I'll stop here.
No, it was very, very interesting. So thank you very much. Maybe our panelists have some reflections to each other, or if not, the floor is open for questions and comments from our participants. And I'm thinking that actually solidarity, is the space for developing corporate responsibility to respect human rights. And actually, I would say that in some situation, when the risks for human rights are so high, we should say that company have not just responsibility to respect, but responsibility to do actually what they can do in this situation. And for me, it's really about business and human rights, not just corporate social responsibility. If we understand corporate social responsibility is in its private dimension, as Florian said in the handbook on business and human rights. So yeah, and actually it also changes our understanding of human rights, I would say, because I don't know if you have the same approach, but for example, in Ukrainian law schools, the first year students often receive the information that human rights demands that we can protect in a court. But I think that actually, in general, business and human rights framework changes our understanding of human rights, because sometimes human rights are expectations and demands that we can't protect in a court, but still we should have other opportunities to realize these demands. So, and that's why I think that the concept of solidarity could help us very much to develop this understanding and to have actually maybe opportunity to rethink this framework that we use for a long time. Yeah. So if we don't have any other reflections, Markus, please.
Thank you very much. If I may, I wanted to jump in on the little, I don't want to call it conflict, but maybe disagreement that you seem to have with Jane concerning the question of whether we are looking at state-owned enterprises, public enterprises, or looking at the function. And maybe, I mean, obviously, I'm not sure whether a German should offer compromise between Slovakia and Ukraine, but maybe Slovenia, I'm sorry. But maybe one way of looking at it could be to say, let's look at the function if it is mandated through some sort of a public legislation, public act. So if it's just the function of the company, I would be reluctant, because then you would also open the door for the companies to say, well, if that's the case, if we do this, then there are some sort of obligations that come with it. But if there is a mandate by the state, then I would see this link where we can actually build on this idea that there is also an obligation to respect.
Thank you for this comment. And I also see that there is a space to develop this issue as well. And Ala, please.
Elena, thank you very much for the floor, and thank you very much for all the speakers from this panel. My name is Ala Timofeyeva. I'm from Charles University in Prague. And I would like to react to what was said by Beata and the other colleagues on the solidarity of business corporations. I will have a question to you, because in the Czech Republic, similarly as in Poland, we have historical experience of the year 1968, when there was an invasion of Russian or Warsaw Treaties group. And of course, for many companies now, it was stopping doing business with Russia. It was now the action which was the expression of solidarity or expression of the feeling what they felt. But on the other side, I don't know what about the other countries, but about your countries, but in the Czech Republic, we also had strong business connections with Russia. There were a lot of companies Czech companies who were exporting to Russia many things. For example, probably you know Czech beer Pilsen, which was exported. And when I talked to the representatives of Pilsner Ukler, the company who exports the beer, they said that yes, we stopped activity with Russia, but they didn't actually comment it on the subject. in more details. And my question is whether this was a really question of solidarity and assistance with Ukraine, or whether it was also the fear of being a black sheep, or those who, like maybe some of the companies, they do not do it sincerely, but they're just afraid that they will probably have some sanctions from the European Union, or just will not be respected by their other partners. But business activities were like very strong, and they lose a lot of money by stopping having business with Russia. So my question is whether I don't know how to prove it, because you cannot, nobody will tell it to you openly, but whether it's possible somehow, whether like all the reactions were only solidarity, but or that some companies had a fear not to conduct business with Russia. Thank you.
Yes, thank you very much. I know that Yerny should go, but maybe very quick comment, because you are expert on this question. Yeah, maybe just very short comment.
Yeah, thank you, Olena. Maybe just briefly to Marcus said, I think this could be one way to find a middle ground, but definitely positive obligations could extend to businesses also, where businesses take over the role of state. Either formally, as you suggest, Marcus, by, for example, concession agreements on any other public contract, or where the state is non-existent, as in many instances around the world, also in the conflict zone, where the states in some areas are non-existent, and where companies take over by circumstances. As far Alia, your question goes, I mean, I'm sure you're aware of reactions of businesses from most of global north or Northern Europe, which reacted very harshly towards aggression, but that approach has not been followed. For example, in the region where I'm from, where I'm based, in Central Europe, or if you go even further east in Western Balkans, where businesses continue to do business with Russian Federation. Not only that, for example, Republic of Serbia serves, since the start of aggression, as a safe harbor for thousands of newly created Russian companies and Russian nationals which fled both Ukraine and Russia, and they established companies there. And Turkey is another example. As far as doing business in Russian Federation, Alia, you know that UNGPs, I think in Article 7 or 8, Principle 7 or 8, if I'm not mistaken, they request states to give a guidance to companies whether to continue to do business in conflict zones or conflict-affected zones. For example, here in Slovenia, most of our largest corporations, they have extensive business relationships with Russian Federation, mostly pharmaceutical, logistic companies, construction companies. And those companies, not only they have continued to do business with the Russian Federation, they have not identified the risks so far of continuing doing business that. And also the Slovenian government, even though it has obligations under UNGPs, international human rights obligations, has so far failed to instruct the companies about the risk of continuing business in the Russian Federation. So Alia, there are different approaches in different regions of Europe. I would wish that the approach perhaps would be more holistic and more uniform. And I would like to thank Olena again. I have to run for my class. Students are waiting for me, but I hope to see all of you very soon.
Yes,
bye.
Thank you, Yerny. Yeah, bye. And I know that Nadia would like to add, to respond to the question that Alla asked. Nadia,
thank you. Just a very brief point, Alla. Thank you for this interesting point that you made and your question. I just wanted to add something. You talked about companies ending their business with Russian partners, perhaps out of fear of being of being shamed or something if they don't. So perhaps questioning their motivations to do it. I want to say that although of course it is an extreme situation, companies, or even in normal times, let's say, have all sorts of motivations to engage with these issues. And whether it's out of fear of getting sued, as us lawyers would like to frame it, or whether it is because they're afraid of their reputation, which is the fear of being sanctioned by their customers if they don't act in a certain way, or whether it's coming from a place of, let's say, of good, that what we're all hoping. But also those motivations can change, especially in large organizations. It's not like there's only one person driving this. So this is very diverse, even in normal times. So I would say, being the utilitarian that I am, that at the end of the day, it's only the result that matters, right? If it is important to end these relationships and to be in line with the sanctions and to show solidarity with the Ukrainian people in this particular context, then whatever the reasons, if it's done, it's done, right? So.
Thank you very much. Yeah, thank you. And Beata, please.
Sure. Just responding to Ala's kind of last question, I think to what was already said. I think in Poland it's a mixture. On one hand, there was a huge pressure. I mean, seriously, Poles are not very. We are not a nation that really goes for boycotts of different types. So a number of calls for boycotts with regards to the fashion industry. They were really, they didn't gather much of the attention. This time it was extreme. And I think a lot of this public pressure and also the feelings that, we are dealing here with a full-scale aggression and war and not just some borderline skirmishes. I think it all added up. A number of Polish big companies really withdrew. Some of them, like LPP, literally, they've been present there for 20 years, and they basically closed off several thousand shops. So for a number of companies, that was very painful in terms of financial consequences. There is, for example, a company, I think it's called Famor, which is making equipment for extractive industry. So given the Russian market, they basically lost 200 million zloty, just kind of what was contracted now. At the same time, there are some companies, but I would say their number is decreasing constantly, like Polpharma, which is a pharmaceutical, Campac, which is doing aluminum cans for internal market in Russia. There's Sanit and so on, but Sanit is already kind of declaring that they want to sell their assets. And all the companies that are still operating in Russia, they've declared that they are basically minimizing their operations and just kind of not going into any new investments. But I think it's kind of a combination. On one hand, it's this public pressure. On the second hand, we hear constantly from their representatives that that was the right thing to do. But there is also this element, with Russia being currently so heavily under sanctions. I do think it's also kind of a very strong element of business thinking that it will be increasingly difficult to operate in Russia. So it's better to withdraw now and divert their resources and focus on other markets. What I'm surprised with is that at the EU level, when we are kind of talking about different sanctions now and expanding the list of sanctions, we suddenly have blockages from Belgium not to put diamonds on the list of sanctions, which I just found really both hilarious, but also really I'm just, it just really took me breathless, because I just really thought, okay, we are having this conflict here, and now diamonds are more important. So, yeah. many things. So I would say, yes, there is still presence, and I think there are just a number of factors that are taken into account by companies when withdrawing. Thanks.
Thank you very much, Beata. And I should say that we have some additional time because unfortunately Sinisa Milatovic, the panelist of our next session, can't join us today, and he asked me to say hi to all of our participants, but he is involved very, very actively in preparing Business and Human Rights Forum in Africa, and I would recommend you to register because I think that there are a lot of interesting information will be there. So we have time for one more comment, and Florian, please, the floor is yours for your comment.
No, I think you can hear me. Very quick comment. I just wanted to quickly react to what Nadia said before. You know, ultimately, I think I agree that only the result matters in the end, but I think it's easy to say if you look at a conflict that's gets a lot of attention and publicity, but I think you can separate the results from the way you get to those results completely, right? If a company sees whether to pull out of Russia or not merely as a business decision, that they say, okay, we're going to weigh maybe the economic cost against the reputational risk. So if we pull out, we may lose our facilities there and so on. So there's an economic cost associated with it. If we don't pull out, then we may have a reputational risk at home because we're not pulling out. And so if it's only a business decision that simply weighs those costs, that may ultimately lead to the right results in a conflict where this reputational risk really is there at home. But if you look at other conflicts where you don't have this reputational risk at home, it may actually lead to the opposite decision. That's why I think you can't completely separate the results from the way to get there. And that this kind of connects or reminds me of, you know, what Beata said in her in her talk about the Polish company for whom reacting to the conflict was simply kind of a matter of an ethical obligation. You could also say, you know, they reacted out of a sense of solidarity in that sense. And that's what I meant when I was talking in the beginning, that solidarity is based on kind of a moral sentiment. You feel drawn to doing something. But of course, there is this limitation, right? So in this particular conflict, they felt like, oh, we have to do something, and whether this is business and human rights or social responsibility, it doesn't really matter because we feel like we have an ethical obligation. But then, of course, you have to wonder, you know, how many of those companies which now rush to help have felt the same sense of urgency for other of the many conflicts that we have in the world, and where those companies could have done something as well. And I think that's where the business and human rights approach is important, to have kind of, you know, to systematize and find a systematic frame for when and how a company actually has an obligation to do something more than just respect, or do something more than just do no harm, right? And so I think that example is really telling and great, because it shows all that is in a sense problematic about simply relying on a sense of solidarity, but also all that is promising about it, because it really creates this urgency to do something, and it doesn't really matter anymore whether we have this obligation or not. So I think this is the kind of force of the concept that we have to harness and maybe expand. And as Nadia said in the very beginning, integrate it into a more systematic business and human rights approach. If you can harness both the systematic approach of business and human rights plus the urgency and force of the sense of morality or solidarity, that I think can be a very powerful combination, right?
Yeah, it's actually perfect point. Thank you very much, Florian. And actually, I don't know, maybe our panelists have the same feeling. I have the feeling that this topic is not comfortable to speak about, because it's not developed enough, yeah, and it's much more comfortable to participate in the discussion on well-developed issues. But I think that it's challenge for us, and it's actually interesting to speak about when we don't have answers to questions that we are discussing today. So thank you very much for this great contribution, and I would like to open our third session, our session 3, Human Rights Due Diligence and Solidarity's Challenges. And our panelists in this session, as I said, Senisha Milatovic, unfortunately, or maybe for Africa, it's success to have Senisha Milatovic. No, so Senisha Milatovic is preparing Forum for Africa, and I wish success with this forum. And we will see Senisha Milatovic during the regional forum on business and human rights in Eastern Europe and Central Asia. And I would recommend again to all our participants to join. This forum will be held on 10th, 11th November this year. So please join us. And our panelists are Dr. Olga Martin Ortega, Professor of International Law at the School of Law and Criminology, the Business, Human Rights and Environmental Research Group, and Olga leads this group in Greenwich. Dr. Chiara Macchi, Assistant Professor in Law at Wageningen University and Research, and Dr. Katerina Buryakovska, Assistant Professor and expert in International Lab on Business and Human Rights in Yaroslav Mudry National Law University. Please, our great panelists, the floor is open. And actually, my question to all of you is about we discussed these solidarity's challenges and we overview environmental issues, conflict issues, and many other global emergencies issues. And also we can look at the solidarity approach in the context of future generations. What actually your reflections about our today's discussion in the context of human rights due diligence approach and expectations on mandatory human rights due diligence in the context of solidarity, and what is the framework of solidarity which we can apply in the context of human rights due diligence. Olga, please, what is your reflection about today's discussion?
Thank you very much. Can you hear me well? Yes. Thank you. Of course, join the rest of the speakers in thanking the Kharkiv Legal Forum, International Legal Forum, and Elena Ubero in particular. It's an absolute privilege for me to be here. And I have to say that also I'm looking forward to receiving one of your colleagues at the University of Greenwich, Dr. Olena Mitnick, which will be joining us as British Academy Scholars at Risk fellow very soon. So in my talk, and I will come to your specific question. In my talk, I want to focus on the consideration of the principle of solidarity in the journey that is currently evolving to a shift from a principle of international law and a principle that, as we know, underpins our contemporary international legal system to a right. So we are in the process of arguing for the principle to become a human right to international solidarity. And I would like to reflect on what this means for the role of private actors, and in particular, specifically regarding the current developments in mandatory human rights due diligence and the hardening of this standard of conduct. So, as has been said, solidarity is a principle of our legal system and is inextricably linked to cooperation. And until now, we focus this cooperation mostly as interstate cooperation. And the very interesting development of defining an international human rights to a human right to international solidarity, which is happening in the context of the mandate of the independent expert on solidarity, is bringing us a widened sense of what solidarity is, or at least consolidating some of these specific elements that we've already mentioned, and it's actually, in my opinion, going to be crucial for the shift between a principle, which is a moral imperative, and therefore we all interpret according to our moral basis, but also, as we know, morals in international law are slippery and depend very much on governments and depend on how states behave. And so this shift from a moral imperative to a right involves, therefore, that there are duty bearers and right holders, and there's specific content of what it is to be able to claim an international right to international solidarity. So in this context, the independent expert on human rights and international solidarity, which is now the third expert, is developing what the second expert, Virginia Dandan, published as the draft declaration on solidarity. And this draft declaration is where she proposes the shift to a human right. So let's have a look at what the draft declaration defines and what are these main elements which will bring me to discuss the way human rights indulgence is developing and to what extent it actually does contain, or it has the main bearings to become a way to articulate solidarity in the private sphere, in the sphere of the private sector. So the draft declaration defines the right to international solidarity as the right, a human right, by which individuals and peoples are entitled, on the basis of equality and non-discrimination, to participate meaningfully in contributing to and enjoying a social and international orders in which all human and fundamental freedoms can be fully realized. This is a principle that is based on the premise that all our international instruments have on international cooperation and on the trust. We've already heard of the concept of trust, but also it's a spirit of unity that encompasses the union of interests, purposes, and actions, and the recognition of different needs and rights to achieve common goals. So I'll come back to this idea of how to bring together different needs and rights in the achievement of a common goal. The principle of solidarity, international solidarity, consists, according to the independent expert in the draft declaration, on preventative solidarity, reactive solidarity, and international cooperation. Preventative solidarity consists on collective actions that will safeguard the fulfillment of human rights. And in this specifically, the reference of the private sector is included. So preventive solidarity is not just what states do in order to fulfill human rights. It's also the private sector to complement the efforts of states. Reactive solidarity are the collective actions that the international community takes to respond to these global challenges, including the human rights impacts of armed conflict. And international cooperation, as we know, is a principle by which all states need to come together to develop and implement their obligations. So what is the general principle, the general objective of solidarity is to enable an environment that engenders trust and mutual respect between states and non-state actors. So it's very clear that non-state actors are part of the duty bearers in terms of the right, individual and community, collective rights of solidarity. So this is important, again, as I said at the beginning, because this then moves from the discretionary actions that non-state actors, private sector can take, into establishing specific obligations, which are very much now complemented with the business and human rights framework. So important elements of the way the right to international solidarity is defined is the extraterritorial reach of human rights obligations, and, as I said, the role of non-state actors. So how does this, therefore, plays out in terms of what states and non-state actors have to do to advance and to fulfill this right? Well, a very important element in the declaration is the concept of policy coherence, even though it's not as such referred explicitly as such, but it does call for states to mainstream human rights and to have all policies that do not interfere with human rights protection and promotion, both within the borders and beyond the borders of the state. We see again the element of extraterritoriality. So as we can see, therefore, international solidarity is not constrained by national borders or by the limitations of international legal personality in international law. So how does this then relate directly to human rights due diligence? Well, then importantly, the concept of the way we've developed human rights due diligence in conflict zones specifically has taken the form of this heightened human rights due diligence. And we can't separate the specific critiques that we're getting with regards to due diligence from, for example, the approaches of third world approaches in international law. We're seeing that states building on this extraterritorial application of human rights and building on the need to include the private sector are in fact starting to develop rules that apply beyond their borders without the participation of those which are impacted by these rules. So what the third world approaches of international law critiques of mandatory human rights due diligence approaches these days is that they perpetuate a situation in which states in the global north create rules that apply in the global south without the participation and without the understanding of what the impact on the communities that receive, that are the recipients of these norms and the recipients of the effects of these norms. So this we can see in the normative developments of mandatory human rights due diligence. We can see a lack of inclusion of rights holders in the discussions. We can see a lack of consideration of workers, communities, farmers, all those that would ultimately receive these impacts. And in principle, of course, we all agree that these should be positive impacts, because if we're regulating the activities of corporations and we're telling them to assess, identify and prevent all these risks, we expect these to be a positive impact. But we don't know. We haven't done enough assessment ourselves with regards of how they apply on the ground and how we may be transferring risks on the ground. So this brings me back to the way the right to international solidarity is being defined as the confluation of rights and needs to achieve common goals. To what extent are we perverting this understanding of solidarity by establishing norms to which recipients have no say or no capacity to interact with? So going back therefore with this premise of caution and this premise of alertness over an issue that it's happening and is being critiqued now by certain approaches to international law, let's look at what human rights due diligence means in the context of conflict in particular. And we know it's a heightened due diligence, so it demands a conflict-sensitive approach, a conflict analysis that goes beyond what's happening in the current dynamics, but also looks at the roots of conflicts and also looks at the way specific relationships are formed, and also demands a consideration of international humanitarian law. And this brings not just this analysis, it brings the need for a responsible exit. And we've already talked about this in the previous panel. What does it mean to leave in terms of those left behind in a way? And this again links with the rights holders perspective of, are we assessing enough the impact of exits from in this case, Russia and even Ukraine, of these companies. But of course, if we also see these solidarity actions by corporate states of exit, for example, but if we see them through the prism of human rights, then what we have to consider, what are specific responsibilities, human rights responsibilities towards those closer to these companies, employees, communities, and we've talked about essential services already. One element as well that this approach, human rights approach to solidarity brings us is the discussion of boycotts and donations. You know, solidarity is not charity, because charity is a discretionary action. Charity doesn't identify rights holders, doesn't identify duty bearers, therefore is not in the spirit of solidarity as a human right. And I want to bring, just to conclude, I want to bring this recent survey by the Business Human Rights Research Center, which has asked over 400 companies of what are their actions related to the aggression of Ukraine. And only out of the 400, only 112 have responded, and most of them just have a statement of condemnation, etc. And most say that they've stopped operations, but none of them have a long-term plan. And again, very few of them consider the impact on the individuals and the collective. So there is less protection, therefore, of rights holders and less understanding that a corporate response need to be part of this wider rights that the people have and the community has to come together, assess needs and rights to the achievement of this common goal, which in this case is the respect of human rights and the fulfillment of human rights of the people of Ukraine. So I leave it there and look forward to the discussion. Thank you.
Yeah, thank you. Thank you very much, Ola. It's actually a very good start and very good framework to our further discussion. And actually, you said that solidarity is mostly about common goals. And I would like to ask Chiara, as an expert on environmental due diligence and human rights due diligence, actually this concept of common goals and the concept of future generations in the context of solidarity, are they relevant to each other? Chiara, please. And actually, what are the applications of these concepts in recent developments?
Thank you very much. First of all, I hope you can hear me well. Thanks for the invitation and congratulations for this great program, and also thanks to the other panelists, because I've taken a lot of notes. Now I have too many things to say and I don't know where to start anymore. But yeah, I wanted perhaps to start from something that Beata said about, she quoted the Article 1 of the Universal Declaration of Human Rights and the concept of brotherhood, for lack of a more gender-inclusive word. And this also made me think about the motto of the French Revolution that perhaps, you know, was one of the embryonic stages of the development of human rights. Liberty, equality, fraternity, and fraternity represents what we may call the third generation rights. And, you know, also pretty much linked to the concept of solidarity rights. And in this intervention, perhaps I will focus a bit more on environmental rights and on the issue of climate change as linked to human rights. And I will say a little bit also about ecocentric rights, or the rights of nature, because I think we must start from the recognition that third generation rights have a big limitation at the moment, that is that they are still scarcely recognized compared to first generation and second generation's rights at the international level. And this, of course, has to do in part with the traditionally individualistic conception of human rights, especially in the Western world and now in the global North. And in part, of course, this scarce recognition of solidarity rights, if you will, stems from the willingness of states to preserve ample room for maneuver, especially in relation to complex structural, economic and social issues, including those global issues such as climate change that have sometimes been defined as wicked or intractable. And I don't need to remind you, this audience in particular, that nowadays even some liberal democracies such as the United States still do not recognize second generation rights as legal entitlements, and they dispute the normative character of the principle of international cooperation that also Olga was talking about. So we still have difficulties affirming second generation rights as legal entitlement, let alone third generation rights. Now, we now know that the most complex issues of our time, including climate change, are by no means intractable, but they need the decisive political and regulatory action on the part of the international community. And more in general, they require overcoming a certain short-termism in the actions and decisions of both governments and companies. And these changes do not simply stem from voluntary commitments on the part of these subjects, but increasingly we can affirm that in fact they derive from legal obligations. First and foremost, of course, state obligation under international law, in particular under international human rights law, for sure, but also increasingly a recognition of obligations that companies bear under various legal frameworks. Now, there are some important developments to observe in relation to third generation rights. Firstly, they are slowly coming to enjoy an increased level of recognition at the domestic and international level. For instance, you all know, I guess, that in 2021, the UN Human Rights Council for the first time recognized the existence of a human right to a safe, clean, healthy, and sustainable environment. It is quite striking that this came 55 years after the adoption of the two UN covenants. And in the same year, the UN also appointed the first special rapporteur tasked with addressing the promotion of human rights in the context of climate change. And also there is an increasing movement with the key role played by the Global South towards recognition of the rights of nature. Now, I don't want to overestimate this process that is still at an embryonic stage, but it is undeniable that in the last 15 years or so, some unprecedented steps have been taken, starting with the recognition by Ecuador in its own constitution in 2008 of the rights of nature. And this then also led to some court cases. In Ecuador, in particular, a successful lawsuit filed against the provincial government for allowing the widening of a road without considering the rights of the Vilcabamba River, and then other lawsuits based on the rights of nature filed in other countries, and in particular developing countries, and countries of the Global South, so Argentina, Pakistan, Colombia, New Zealand, and so on. So what is particularly interesting, I think, about the rights of nature movement is that local organizations and indigenous populations are acting and can be recognized as well as guardians of the legal rights of ecosystems, rivers, lakes, and so on. And therefore, they have the potential to generate a productive synergy between the protection of the rights of nature, but also human rights and indigenous peoples' rights movements, especially indeed in the global south, that could become, in a way, the leader of this new movement and of new legal developments. And this, in turn, can help better regulate the activities of corporations and ensuring a more consistent and effective application, for instance, of environmental impact assessment, but also a more meaningful involvement of local communities in decision-making, because this is also, I find, the limitation of the current draft directive of the European Union on mandatory due diligence, that stakeholder involvement is very limited. And then I also understand that while criticism towards mandatory due diligence, because of course there is little consideration in general for the positions and voices of communities on the ground. And then, of course, in parallel with the growing recognition of third generation rights, we also see the trend towards climate change litigation that aims at pinpointing the legal obligations of individual states and individual corporations for failure to address climate change or for their contribution to climate change. And again, we are slowly overcoming the outdated and largely instrumentalized idea that no individual responsibility can be identified for a global phenomenon whose very existence has also been denied until very recently. Now, the recognition of collective rights is still very limited in international human rights law and in the global north, and the same can be said about environmental rights, at least under international human rights law. But this trend of climate change litigation shows how it is possible to strategically use legal instruments at the domestic and international level to indirectly enforce some form of solidarity rights, at least in the realm of climate change and the environment. And it is also coming back to what other speakers have said and what Olena was asking, a coherent understanding of solidarity has a clear link with the concept of dignity, as Nadia said, but also arguably a transnational and transgenerational dimension. Indeed, the climate change litigation is advancing the debate on these issues. Many of the court cases that have been filed, in particular the two successful cases in the Netherlands, also refer to the rights of future generations, and they were promoted in defense of current and future generations, in this case of Dutch residents. But there are also interesting cases pending or already decided in front of UN human rights committees that are advancing the debate on extraterritorial obligations, also already mentioned by some of the speakers. For instance, the Saki and others case filed before the Committee on the Rights of the Child that was declared inadmissible, but in the inadmissibility decision, the committee said very interesting things about how states have an obligation to control the extraterritorial effect or negative impacts on human rights stemming from activities taking place in their territory or jurisdiction. So it is very important to note how developments in the field of, in particular, climate change and the link between climate change and human rights, but also in the field of, in general, let's call it business and human rights litigation or parent company liability, are blurring some of the self-imposed intellectual prisons, to paraphrase Rosalind Higgins, like, for instance, the whole debate about the international legal personality of corporations. Like, we don't need to affirm that in order to recognize that corporations have certain responsibilities and duties in relation to human rights and the environment, but also the corporate veil, climate change litigation and parent company litigation, especially in the UK and in the Netherlands, is increasingly affirming that the parent company with a policy setting role within the corporate group also have corresponding duty of care in relation to its foreign subsidiaries and their impacts on human rights and the environment. And then, of course, talking about the responsibilities of corporations, it is really a groundbreaking development that was arguably unthinkable until 10, 15 years ago, to note that certain states and now also the European Union are affirming an obligation for companies to conduct human rights and also to some extent environmental due diligence. Of course, the UNGPs were already a hard-won compromise in a way. They have been criticized for being under-ambitious and so on. But actually, in the last decade, I think the UNGPs did what soft law is supposed to do, meaning they were the springboard for hard law developments that were really unthinkable until recently. And it's important to note that some of the emerging legislations on mandatory due diligence also entail an environmental and potentially climate change dimension. This is still far from affirming or recognizing solidarity rights, and there are still many limitations, of course, in how these instruments are conceived and designed, and perhaps we can talk about this during the Q&A. But undeniably, these are landmark developments that can really advance corporate accountability for environmental and climate change impacts. And of course, here there are still many challenges to address. Incorporating some form of solidarity rights in the notion of due diligence presents many questions, such as, if we affirm that businesses should mitigate their impact on climate change, then how do we measure and quantify such impact and the needed reduction and the needed mitigation? And the Dutch courts, for instance, try to give some guidance about that, but this question remains largely underdeveloped. And also, if we talk about the rights of nature, this is a bit more forward-looking. Then what are the nature's legal guardians claiming on nature's behalf, and who has a say, for instance, on rivers that span across several jurisdictions? So there are still many issues to be addressed, especially because the recognition of these rights is still limited in domestic and international legal systems. But what happened in the last decade concerning the recognition of the human rights responsibilities of corporations should teach us that an unprecedented legal development is by no means an impossible legal development. So there is room for new groundbreaking changes in my view. Thank you so much.
Yeah, thank you, Kara. Totally agree. And actually, I think that the key challenge to have so prominent names during the panel discussion is to limit speakers with just 5-6 minutes, because each of you could be a keynote speaker for sure. And all issues that we discussed today are almost in the line voluntary and obligatory, soft law, hard law, corporate social responsibility, business and human rights, and so on. And that's why our next speaker has a challenging question, a question about criminal law. So, Katerina, could I ask you, how do you think, what is the solidarity response to situations when businesses are complicit to international crimes?
Thank you, dear Elena, and good afternoon. And hello to everyone who is present in this panel discussion. I'm really very delighted and very happy to participate in its prominent discussion, and more of that, to see very well-known faces here, which remind me our warm times when we spent the second part of September or the beginning of October within the annual legal forum. Yes, indeed, I took a risk to combine this, as Nadia said, underexplored concept of solidarity, to combine it with other two underexplored concepts, which are universal jurisdiction and criminal corporate responsibility. I must say that I was really inspired to talk about it during panel discussion. I was inspired by my participation in an international Nuremberg Principles Summer School, which I had an honor to take part this summer, where the corporate criminal responsibility issues were paid so little attention to. And my questions to facilitators and to outstanding lecturers on how could we fill the gap of criminal corporate responsibilities in cases of international crimes were very coldly responded with undoubtful answers that there is no room for corporations to be punished for committing international crimes. And actually my considerations on universal jurisdiction as a means to punish corporations and an instrument. I would, however, like to start with the new, which came recently from the ICC. So last Thursday, the International Criminal Court in The Hague opened the trial of one of the last major suspects in 1994 Rwandan genocide. That is the 87 years old businessman who was a radio station owner, and he is accused of helping, funding, and promoting mass killings in Rwanda in 1994. So actually he was a chief financier of the radio station, through which during the genocide, people were instructed on how to create barriers, how to carry out searches, through this radio station, persons' names were named to be targeted and pointed out the areas to attack. And also he is also charged in supplying and purchasing different weapons for a Hutu paramilitary group, which neighbors were the main perpetrators of Rwandan genocide, and UN says that were 1 million people killed for 100 days. So also the ICC has no jurisdiction over corporations. It is very well known, but I think that this trial, this effort and attempt sends us the sign, but I hope not for us, but for corporations, especially multinational corporations, that not only perpetrators with guns in their hands or military commanders who issue orders are committing crimes, but we also have always keep in mind that those who aid, abet, endorse international crimes, or somehow benefit from this cruelty and violations of human rights should be also taken to responsibility. But in general, it's obvious that international criminal justice is likely reluctant to prosecute businesses and legal entities. But though in terms of transitional justice and restoration, and I think that this intergenerational justice, it is extremely necessary to consider the ways of filling these gaps to open and trigger criminal investigations against corporations and issue conviction judgments. And the very important thing here is to think about the conviction sanctions, so that companies could suffer such losses which could be like similar to international deaths, and they could never benefit from historical impunity, because putting responsibility on them as entities, no individuals, in themselves puts an end to the argument that abuses committed were the work of some like few black sheep, but not companies. In today's world, the rise of corporate involvement to wars and mass atrocities looks like unprecedented. And it goes without saying the level of business and corporate criminal alleged involvement of companies to Russian aggression against Ukraine, I think has got its brand new way of being, because many transnational companies are alleged to complicit not only to atrocity crimes, which of course this is the subject to criminal investigations. We are talking only about alleged crimes. But there is the allegations that these companies contribute to the crime of aggression, which is the crime of crimes, because its commitment undermines the very fundamental universal order prescribed by the UN Charter. And I think that this is one of the points which should be discussed definitely. While the prosecution of aggression by national courts is still contested in experts and scholars and politicians and political debates, in other cases, it is obvious that there is no obstacles for joining the efforts of as many stakeholders as it is possible and expressing solidarity to stop impunity of businesses which contribute and complicit to international crimes. And it seems that universal jurisdiction as a legal instrument can be the appropriate response to this challenge. Just briefly, the principle of universal jurisdiction, this is sometimes it is called exceptional way of exercising jurisdiction over crimes, when the country can investigate, charge, investigate, and issue court judgments, convictional judgments against people who are not somehow linked to this country, which committed crimes abroad, and these crimes don't have any link to the country which is now investigating or charging the person. So really it is sometimes called an exceptional way of exercising jurisdiction. But why it has and took place in many countries? Because the idea of universal jurisdiction is that this is the kind of agreement between countries, and this agreement says that international crimes, they are so offending the community of humankind that they should be prosecuted in spite of traditional conceptions of sovereignty. And this is the situation when, I think that this is the situation when the law paves the way for solidarity. But on the other hand, as soon as this concept of universal jurisdiction is not like binding so far, then it really looks like voluntary legal instrument, which can be triggered only if the country has this will to join the efforts of solidarity. And this universal jurisdiction instrument, I think it seems like very helpful in cases when the country where the crimes committed, especially conflict-affected countries, they have no capability for investigation for different reasons. Or when which happens frequently, when the suspicious are hiding in the country, which has no connection, but this country wants to punish this person because she or he allegedly committed the international crime, which really threats the whole society. And when I was looking through the different cases in this regard, of course, I have found that, and it's not surprising that, for example, the Netherlands, it's really called in the literature as an interesting laboratory for BHR litigation and criminal as well, because in the Netherlands, the legal ground underlying the principle of universal jurisdiction is the fulfillment of states' international obligations combined with the nature of crimes, of international crimes, against the interests of international community as a whole. So the Netherlands see itself like the instrument to protect the international community. But yes, as I have already said, so far there is no evidence that universal jurisdiction is an obligation, especially in regard with corporate criminal responsibility. But in this connection, I cannot to mention the draft articles on prevention and punishment of crimes against humanity, which was prepared by International Law Commission in 2019, the very relevant draft of this document. And it is very interesting from the 2 points of view. First of all, because this is the first draft of legal binding instrument, which says that legal persons should be also punished for the crime, for committing or complicity or aiding or abetting to crimes against humanity. And the other provision, which is crucial in this regard, I think that it says that this document does not exclude that the states could exercise any other jurisdiction except of like classical territorial jurisdiction established by a state in accordance with its law. So I think from the point of view of my interpretation of this provision, it opens the way for universal jurisdiction for punishing corporations which contribute to committing crimes. Yes, but on the other hand, we have another draft document, which is draft document of a legal binding instrument on business and human rights. And many experts are very sad about the fact that corporate criminal responsibility is at the moment excluded from the second revised draft. Well, actually, as for some words about Ukraine, because in its April resolution, European Union on war in Ukraine, among other things, European Commission endorsed taking the advantage of universal jurisdiction in prosecuting crimes, international crimes committed within the war in Ukraine. And as far as you might know, that there are at least we can talk about one joint investigational team, which which is actually the joining of countries of Europe and EU members, which will be together conducting investigations of international crimes committed on within the war in Ukraine. And I really hope that the criminal corporate responsibility can be at least discussed to be implemented in the work of this joint investigational team, because this is actually the reflection of universal jurisdiction. It means that these countries on their territories will trigger the investigations, will open the investigations. And from the analysis of different cases, which not so many cases of universal jurisdiction over corporations, we can talk about two or three of them, which took place in France and in the Netherlands. I can talk about some challenges or lessons learned, which can be used by our by universal jurisdiction courts related to Ukrainian situation. So first of all is the some countries may be reluctant to trigger the investigations for different reasons. And some of these reasons is very simple, that these investigational bodies could not appropriate and understand the meaning of due diligence and corporate responsibility of companies in the context of armed conflict. Also, there is a challenge of clarifying the mens rea element of knowing or not knowing that the company is complicit in the international crimes. And in this regard, some courts, for example, in France, they put the very low threshold. So they say that we do not require the intention to participate of corporations in committing crimes, but it is enough for us to see that the knowledge and awareness of companies that money was paid to armed groups committing crimes. So it is really very challenging, the classical concept of complicity in international criminal law. And also, I think in the context of Ukraine, the very interesting thing, one of the interesting things is the responsibility of private military and security companies. For example, in the case of Wagner Group, which is on the one side is called private military security group, but it seems like state-owned on the different facts. And the last challenge, not challenge, but lesson learned, is the civil society organizations' contribution to that. So in that cases when we had universal jurisdiction cases over criminal corporate responsibility, civil society organization and think tank organizations were the drivers of that processes, because when in Lafarge case in France, the case was, this is the one of the prominent examples of universal jurisdiction over corporate criminal responsibility, and this case was triggered by the French Minister of Finance complaint before the Paris prosecutor, and he said only about that this company is illegally purchasing oil in Syria despite the EU embargo. But when civil society organizations joined this process, they proved that this is the case not only about overcoming EU sanctions, but this case is about contributing to crimes against humanity. I think that these things should be discussed, and they can be helpful for future potential international tribunals, whatever nature they will have. But they will definitely have to follow the broad approach of perpetrators on the field and not on the field. Thank you for your attention. I will be glad to take part in discussions.
Yeah. Thank you very much, Katerina. And actually, I really like that we have so many different dimensions of the issue of solidarity. And actually, I feel that we have the puzzled picture, and it would be very interesting yet to see the picture in whole. But I think that we will need some time after the forum to rethink all information that we obtain today. And to be honest, I'm going to prepare something like executive summary of our panel discussion and to share with all our speakers, and then after their comments and reflections with all our participants, because too many things were raised, and extremely many dimensions. And I would like just to ask our panelists. I like this point about civil society organizations contribution, and my question mostly to Chiara and to Olga, how do you see the role of civil society organizations in developing this solidarity approach and their roles in this environmental issues or cases, and do this draft of the Treaty on International Solidarity raise the role of civil society organizations and human rights defenders somehow? Chiara, please.
Yes, so I will let perhaps Olga answer on the draft declaration, but in general, I think civil society can have an important role, as it has been in the past with many, for instance, negotiations of new human rights instruments. I'm thinking about the recognition of the right to water, but also indeed of the right to the environment, but also negotiation of the optional protocol to the International Covenant on Economic, Social and Cultural Rights. These were developments that were pretty much resisted by at least some states, and the civil society with its lobbying and its, critical mass building really had a crucial role in pushing the bar a bit further in developing human rights and human rights instruments. So in this respect, also concerning the rights of nature, I am convinced that this will be what will happen. I don't know how long it will take, but already civil society, and this is most interesting because it is especially in the global south, is leading the way, and also indigenous peoples organizations are leading the way. In terms of human rights due diligence specifically, I think NGOs, local communities really play an important role as watchdogs or supervisors of the activities of corporations, and also the lack of activity by local authorities. And very often they are also the victims then of the resulting impacts. So what I find concerning is indeed the lack of emphasis in the current draft directive on mandatory sustainability due diligence of the European Union on meaningful involvement and consultation of local communities. So I think this is something that needs to be worked on more extensively, perhaps in the next rounds of the legislative process at the EU level.
Thank you, dear Chiara. Olga, please.
Great, thank you. This is a very important point, and obviously the draft declaration on the right to international solidarity does include a prominent role of civil society. Specifically, I've just done a super quick search to just make sure that I didn't lose any of the mentions, but when defining preventative solidarity, collective actions that involve individuals, people, civil society, and the private sector. And also specifically when talking about extraterritoriality, establishes that the individuals and peoples have the right to individually or in association with others claim the right of international solidarity beyond their territories, with a specific mention of civil society groups. So civil society is key, and I share with Chiara the real concern of the lack of presence of civil society in the EU draft directive, and how this could have a real impact on future national legislations, and how, to what extent we really need these organizations to be able to bring to the table the real assessments of impact on the ground, but also the voices of those impacted. However, as well, a word of caution, and we know this, and who is civil society and who represents the voice of society, and this we've discussed a lot in terms of when we're looking, for example, at worker-driven monitoring processes of supply chains or worker-driven remedy processes. So who are the workers? Also in transitional justice, who are the victims or the survivors of atrocities? So who has the, going back to this moral imperative, who has the moral imperative, but also the moral voice on this? And the international expert on solidarity in his latest report on security and the rights of refugees actually does raise an important concern on how some civil society organizations are actually using their capacity to be at the table and their capacity to be heard to advocate against refugee rights. And he mentioned specifically Defend Europe, which is a right-wing organization that has been very vocal in limiting the rights and the efforts of solidarity towards refugees, including in the case of Ukraine. So, of course, civil society is absolutely crucial actor, but who really represents and who has the authority to be part of the process is something that I think we still need to discuss much more.
Yeah, true. Totally agree. And actually, it's a pity that we should finish this part of our panel discussion. I am so much thankful to all our panelists, to all our participants. I should also announce that the second part of our panel discussion today will be practical oriented. We will discuss forced migration in the context of the risk of forced labor and the role of private actors. And also we will have the separate webinar on, I would say, favorite business and human rights tools. So we will have guests and they will share with us what business and human rights tools are favorite for them. So it should be just for fun, but still with some practical use. So please stay with us. Now we will have a break by 1 p.m. Central European time, 2 p.m. Kyiv time, and we will be back at accordingly 1 p.m., 2 p.m. Kyiv time. So looking forward to continue our discussion, and I totally agree that our first part of panel discussion gives us a lot of information to think about and to have more focused discussion in the future. And thank you one more time to all our panelists.
Thank you, Olga. Thank you, everyone.
Шановні колеги, вітаю. Ми продовжуємо нашу роботу.
Dear colleagues, welcome. And we continue with the second part of our panel discussion. Here I'm going to speak Ukrainian and you can use your interpretation function. Our interpreters are working and we're very grateful to them for this intensive work. And now we start the next event. And this is going to be about forced migration in the context of the war and the role of private actors to minimize the risks of forced labor. And today, our key speakers are going to be representatives of the Secretariat of the Parliamentary Commissioner for Human Rights in Ukraine. And further on, I will separately introduce Olena Antonenko, who is Deputy Head of the Department for Prevention of Domestic Violence and Human Trafficking of the Department for Rights and Freedoms of the Secretariat of the Parliamentary Commissioner. Ms. Beata Farachik, she is Chair of the Board of the Polish Institute for Human Rights and Business. Mr. Pancho Volchanov, President of the Institute for Business and Human Rights in Moldova. Ms. Alla Timofeeva, Associate Professor, and she is member of the Center for Human Rights in Czech Republic. And also me, I will also engage in this discussion. Let me immediately address and explain the objective of this event and why we have decided on this theme, on this discussion, and how we see this combination, the forced migration, forced labor, and why we speak about that today in the context of the responsible behavior of businesses. Let me introduce some background. With partners from the Polish Institute for Human Rights and Business, with our Moldavian, Slovak, Czech partners from Georgia, Belarus. A year ago, actually, we decided to hold a survey in our countries and to compare the context of our countries and how the business and human rights framework and the efforts invested or not invested by the states, by the governments to implement the guiding principles, UN principles for business and human rights, how that framework impacts the achievements, success of the state to prevention of forced labor. In particular, prevention of forced labor where the vulnerable groups are migrants. So from the very start of that, we expected that we would rely on experience of the Polish Institute for Human Rights and Business, and Ms. Beata Farachik will further share their experience with us. And we wanted to make use of this experience in the context of our countries. So our idea was that, and we still have that idea actually, and this was the activity that was initially supported by the International Visegrad Fund. But then, because of the war, we shifted the accents, and we are grateful to the International Visegrad Fund for their being flexible there. So we shifted the focus on forced migration and forced labor also in the context of the war. And the very framework of the business and human rights, we also consider that in the context of the war. And among these various factors, variety of factors, we try to detect some general trends and suggest some algorithms how to act for business entities, for public authorities as well, how the state could contribute to responsible behavior in this context. So today, currently we have prepared several national surveys that address the general context of business and human rights in our countries, and also the situation regarding forced labor and how it has been impacted by the war in Ukraine. Because actually the countries that from the very beginning were involved into that survey, they experienced the greatest impact of the war and of the respective forced migration. That is why today we'd like to plan it in this way. The Secretariat of the Parliamentary Commissioner representative will present the information that the Secretariat has so far. This is about human trafficking and about the vision of the Secretariat regarding sufficiency, adequacy, or non-adequacy of the legislative framework that we have now, those activities that are being implemented, vulnerable groups that should be taken into account. Then the Polish Institute for Human Rights and Business, Beata Tracek, will share their elaborations. In particular, they developed a handbook, a guide, which Beata will present, and we will have a discussion on how to apply that in the Ukrainian context, and other partners, how they can use that in their context. And also, representatives of the Commissioner for Human Rights Secretariat have suggested very reasonably when we discussed the webinar that we cannot but take into account the factor of undeclared labor, informal labor employment, which is quite relevant for our region. And that is something that must be taken into account when we speak about forced labor-related risks in the situation of the war. Mr. Pancho Verlanov and Alla Timofeyeva, they will speak about the experience of their countries, the challenges that they encounter in the context, and the steps taken. For Alla Timofeyeva, she will tell us later if she will be able to join us because she has an overlap. So that's the plan for us for this webinar. We expect that it's going to be a very practical discussion on the issues, on the tools to address those, the experience already available that we can use. And thus, we will come up with recommendations for various stakeholders, entities that could impact further developments and the development of responsible business behavior. This could be the state or civil society, business associations, trade unions. So actually, these recipients of these recommendations could be a wide range of stakeholders involved. So to start with, I'd like to show you a video which was recommended by Beata Tracek as an introduction to the issue. Let's try and watch it. I hope that it will work, that you will hear that. Do you hear the sound? Let me know if you can hear the sound. No sound, I'm afraid. So you don't hear that, right? Okay, you don't hear that. Then, in order not to waste time for technical aspects, let me send this link to the chat box. Oh, I mean, that's a very good illustration for the issue that we're going to discuss, but I won't be able to address that technical issue quickly. So anyway, I am now happy to pass the floor to Olena Antonenko, and she will share with us some information about the vision of the Commissioner Secretariat, the information available, what steps are going to be undertaken there. Good afternoon to everyone here, and let me express gratitude to organizers of today's event. Thank you for inviting for this opportunity to join the discussion. The relevance of this discussion can hardly be overestimated. Full-fledged Russia-Ukraine war that started on the 24th of February with the treacherous attack of the Russian Federation on Ukraine has resulted in unprecedented since the Second World War phenomenon of massive migration of the Ukrainian population and the appearance of the previously not known to Ukraine phenomenon of millions of forced migrants, IDPs, refugees, seekers, seekers, and so on. In the recent centuries, there have been a lot of migration crises from Afghanistan, 6 million refugees, Venezuela, Syria, almost 3 million each. But by scale, geography, and the quantitative indicators as well as temporal indicators, the current Ukrainian forced migration crisis is unprecedented, and it is beyond all the previous crises. The hostilities that are ongoing in the territory of our state for 8 years now make Ukrainians especially vulnerable to the situation of forced labor, and we believe that that is an important component of the phenomenon of human trafficking. After the onset of Russia's invasion, the risk to become a victim, to fall victim of exploitation increased. In the Universal Declaration of Human Rights, there are stipulation of the foundational rights regarding the rights of people, and according to the declaration, everyone can leave any country, including their home country, and come back to their country. Everyone has the right to look for the refuge or shelter, and everyone has the right to citizenship. No one can be deprived of citizenship without reasons, or have the right and the right to change, to switch citizenship. In contrast to voluntary migration situation, where the status usually improves, in a forced migration situation, the people lose their welfare and their income. When we speak about forced migration, this is about the absence of positive motivation for displacement and changed living conditions, where it is no longer possible to live under normal circumstances, and where there are threats to safety without normalization of the situation. Forced labor as a form of human trafficking is developing. Unfortunately, the Russian military aggression in Ukraine significantly increased the number of people who have left or who plan to leave the territory of Ukraine because of the hostilities. They encounter a lot of risks where they may find themselves in the situations of human trafficking and forced labor. A human rights commissioner in Ukraine pay special attention to respect of human rights of people who fall victim of human trafficking, because that undermines foundational rights of every citizen according to the Ukrainian constitution. And this is right to life, dignity, freedom and integrity, freedom of movement, and so on and so forth. Based on results of monitoring that the Secretariat conducted, we came up with recommendations for proper response in the situation of human trafficking and how to provide assistance to the victim or to survivors and activity steps to counteract the phenomenon. Over the 9 months of 2022, we have conducted 14 desk monitorings in the field of prevention of human trafficking. And the national service providing authority in Ukraine established 28 statuses of survivors of human trafficking. According to prosecutor's office, 87 criminal proceedings have been registered under Article 149 of the Criminal Code, which is human trafficking or other illegal contracts involving humans. But we also see a significant reduction in the number of status confirmation cases. In 2021, this status was established for 64 individuals. This year, it is 28 so far. That phenomenon has not disappeared, of course, and we believe that these figures are impacted by the hostilities that are ongoing. As a result of those, we see the reduced number of status confirmations. During 9 months of 2022, most of the individuals for whom the status was confirmed suffered as a result of involvement into criminal activities. There was also labor exploitation, forced labor, and begging using in armed conflicts and sexual exploitation. So we observe significant reduction in the number of statuses confirmed, but we need to take the fact into account that human trafficking is a latent phenomenon. Among the most vulnerable groups of population in the territory of Ukraine, let me mention IDPs, internally displaced people. According to official statistics of the Ministry of Social Policy, as of the 1st of October, the number of IDPs in Ukraine is almost 5 million people. Among them, those who need employment, that's 123,000. At the same time, according to IOM information, they conducted express assessment of the general situation of the Ukrainian population. As of the 1st of September, there were more than 6 million of IDPs in the territory of Ukraine. Also, according to IOM survey, 60% of individuals who had a job before the war lost their job because of the war. Before displacement, the key sectors of employment of IDPs were trade, services, education, construction, metal production, and only 28% of internally displaced people who were unemployed before the war or lost their job because of the war and tried to find a job at the host community. As of the 1st of September, only this proportion of people could find a job. This significant wave of migration increases responsibility of businesses, economic entities who hire those people who had to flee from the war, and these people have to look for maybe new opportunities and develop new skills. Employers need to stick with clear and transparent employment terms and conditions and respect the right to decent labor and remuneration. And since the 1st of September, the State Labor Service started implementing an information campaign in order to activate, to involve the population in formal employment. So the transparent businesses, proper payment of wages, prevention of any forms of psychological pressure, and developing transparent contracts, avoiding the abuse of this stuff would contribute to prevention of human trafficking and forced labor. The humanitarian catastrophe that we now observe in our cities, daily shellings by the enemy, these are the factors that make our compatriots flee from Ukraine, from their homes, looking for assistance abroad. According to the UNHCR representative office in Ukraine, more than 13 million people have left Ukraine. Mostly those are women, children, elderly people, and people with disabilities. As of the 1st of October, more than 7.5 million of Ukrainian refugees stay in Europe, and the risks to fall victim of exploitation abroad are also higher. Our compatriots fleeing from the war sometimes did not have the respective documents on them, and after they arrived to the host country, they were not aware of the requirements to register with the consulate. That results in the high risks of falling victim of human trafficking. And our refugees in Ukraine, women, children, people with disabilities, in this way are new opportunities for human traffickers because hostilities, the war is a perfect situation for this criminal activity. Forced labor is not always seen by Ukrainians as a situation of human trafficking. And thus people believe that, for example, they were cheated on, that somebody promised to pay for some job but did not, or revised working hours without revising the wages. So most Ukrainians agree to undertake any job, not to stay without any subsistence, any income in another country, because they have to provide for their children or for their elderly parents. Unfortunately, finding oneself in this situation of human trafficking is rather tabooed. The survivors are afraid of publicity. And we need to pay more attention to respect of the right to information about potential risks and consequences of being in the situation of human trafficking and forced labor. Our compatriots, those who flee from the war, who try to rescue lives of their dear ones, those who can be forcibly involved into certain activities, need to know the clear algorithm of how to act in that situation, where to go, which documents they need, the guaranteed types of assistance that these people can access. And most importantly, when facing the situations of human trafficking, that is not a precondition for expulsion from the host country, and that's important, an important message that needs to be conveyed. And I believe that it is important that everyone at our respective levels consolidated efforts to enhance the already ongoing collaboration in the field of prevention of human trafficking and forced labor in order to protect rights and freedoms of Ukrainian citizens. And thank you for your attention. Glory to Ukraine. Glory to heroes. Thank you, Olena. Thank you for this very detailed analysis that really helps us see the actual situation, what's going on now. And I'd like to address Beata Feracek now. What are the public authorities in Poland that you worked with and that you work with when you work on the issue of prevention of forced labor? Actually, I have a lot of questions to you about that, and why and how you involve businesses into that, and what has changed actually after the onset of the war in Ukraine. So let's start with that, and maybe you can share your knowledge with us.
Thank you very much, Elena. I'll just let me share the screen, and then I'll go into the details. And many thanks for giving us the floor to share it. Let me just. Okay. Maybe I should start from responding to the last question, what has changed? I would say from the perspective of business, when it comes to the activities or actions that they should be undertaking to prevent forced labor or identify the cases, I wouldn't say that a lot has changed. I mean, companies would need to be naturally kind of more understanding and collaborating with Polish authorities regarding those people who had to flee Ukraine without any documents. But then there are also different, the state has undertaken ways to somehow integrate those people into the system and provide them with, some sort of documentation that companies could look at to help them identify people. But generally, I would say that what companies need to do as part of their normal due diligence hasn't changed that much. There are kind of the details that they would need to be more attentive to, and some slight changes in the legislation concerning also who can work in Poland after the 24th of February, because obviously there are different rules for Ukrainians who came to Poland after 24th of February and those who came before. The regulations are much more flexible also in terms of being able to undertake work straight away, and also having access to social security and medical insurance and everything like that. But I'm saying that those are details because kind of the whole series of what companies need to do hasn't changed that much, really. What we've noticed, obviously, with all the influx of the refugees was that at the beginning, there wasn't much of the coordinated action on the Polish side, on the side of the Polish government at the borders. And I mean, we had like a huge number of volunteers who were coming with their private cars to the Polish-Ukrainian border, offering people transport to either cities in Poland or abroad. And that's where organizations like, for example, Foundation La Strada started to point out to some cases which were notified of, people who are seeking, who are starting to approach particularly women with some offers of job, not necessarily in those sectors that they would be interested. Namely, there started to be some notifications of sex traffickers appearing at the border at the discuss of being a volunteer who wants to help. Very quickly, this was notified to the police, so additional patrols were deployed, as well as plenty of leaflets were distributed with information to people fleeing from Ukraine, like what they should look at, what they should be asking for when somebody is offering them a free transfer. Also what NGOs actually did, because we felt that there was not enough of action on the side of the Polish companies, was basically trying to get in touch also with Interpol and notify also German security services, security like police and border guards, to also control the different buses and other cars coming from Poland, despite of the lack of borders, to make sure that simply if there is some trafficking taking place from the Polish-Ukrainian border across to the west, so that this can be perhaps also identified further down. So that's kind of what changed in terms of the situation, simply because I would say at that time, looking from how companies could contribute or prevent contributing to the trafficking and forced labor was basically for those companies that were renting out their buses and minibuses to kind of be careful about to whom they are renting those vehicles. But that was kind of the one very specific sector. But I've started by saying that what companies would need to do, actually, perhaps I should just, then I would need to ask you to tell me when I'm going over time at some point.
Okay, I will let you know.
Okay. So what companies would need to do and what we've developed. Like, in my opinion, really, there isn't much of the difference between what they should be doing in the peaceful times and what they should be doing at the times of conflict, with this kind of more technical differences. And in Poland, in 2017, there was National Action Plan on Business and Human Rights adopted. And while it wasn't very concrete on a number of issues, one of the areas where the government made commitments to improve situation was prevention of forced labor and trafficking for the purpose of the forced labor. There weren't many concrete issues pointed out, but at the same time, at the Ministry of Funds and Regional Policy, basically what was created was another emanation of Committee on Sustainable Development and CSR. And within this grouping, which is a multi-stakeholder body, which has advisory role to the minister, and which really comprises both the administration, representatives of business associations, representatives of some big companies, but also NGOs and academics. And within this committee, several groups were established. And one of those groups was Working Group on Relations with Workers, which at that time, coinciding with the National Action Plan, started to work also on different things aimed to improve situation regarding forced labor and obviously prevention of forced labor. The task that we've been tasked with was basically, on the one hand, to develop, to develop the definition of the forced labor to be included in the criminal code. And here the main issue was simply that in Poland, we did have in the criminal code crime of trafficking in human beings for the purpose of the forced labor. But unfortunately, we didn't have forced labor per se. So as soon as this element of trafficking was gone, you could not really persecute somebody for the forced labor with all the heaviness of this exploitation. What you could have done really was just getting employer fined for abusing workers' rights. And obviously there is a difference between somebody not paying a worker on time once or two times and somebody who is actually fully exploiting another human being. So one of the tasks that we were given was to develop the definition of forced labor. Second was development of the toolkit for companies. We very often hear from companies who are asked to conduct human rights due diligence that, well, they are basically saying, oh, it's too big, it's too much, it's impossible to do, it's not doable. Well, as Anita Ramasastri recently kind of reminded participants of the CISA Summer Academy, businesses are very innovative actors. And I think as soon as they are helped to understand the issue and to break it down, they can really tackle a number of challenges. And that's actually what we have seen when we've worked on this toolkit for companies on how to prevent forced labor and how to identify it. And I'll tell about it in a moment. We wouldn't be able to develop a meaningful and really operational toolkit without the involvement of business. So I'm really extremely grateful to those companies and business associations who were involved in this process. Additionally, as part of this tool of developing of the toolkit, we've identified a number of legal barriers and impediments that make identification and prevention and persecution of forced labor more difficult than it could have been if the law of the country were not sometimes contradictory, if they were properly enforced, if the practice of their implementation was really different. So what we did as well was basically gathering all those issues that came up when working on the toolkit. And we've developed recommendations for the Polish administration. And then we've got also an additional toolkit on how to create a safe and sustainable work environment. But this one I'll leave aside, as it's not directly linked with this session. We did also some workshops and seminars so as to introduce individual tools. As I meant, like Olena was very kind to say that it was Polish Institute that developed the toolkit. Well, we had the role of the coordinator, so certainly we did contribute a lot also in terms of coordinating all the work. But to be fair, it wouldn't be possible without the involvement of the ministry, which was providing very, very strong support also as a secretariat, but also of all the companies and NGOs and academics who are involved in the process, as well as public administration. So we have such companies as ABRIS, as Budimex, LPP, but also organizations like IOM and different ministries and Polish institutions like Office for the Protection of the Personal Data. But we also had trade unions, as well as some of the companies who are operating from outside, who are actually foreign companies, but operating in Poland. And the practical insight from all those parties was incredibly crucial to actually develop individual tools. It wouldn't be seriously possible without the practical knowledge also from the companies where they are having challenges actually accessing some information when they want to verify if a person is employed legally or not through the agency. And I would want really to encourage colleagues from other countries to really engage with all the stakeholders when developing such tools. I mean, NGO won't have an insight into what is a problem when you're a company and you want some data from your supplier. And you won't be able to develop proper, even contractual clauses or consent for the workers, if necessary, without some verification and advice and discussions with the Office for Personal Data Protection, and so on. And the view from the trade unions as well is very, very crucial, also in terms of where to seek additional information. So it all adds up, and it's really a collective knowledge that results in a toolkit, which is currently, as we know, really used with success by not only by the participating companies like Lubava or LPP or Budimex, but also by a number of others. And we've been already told by Lubava that actually being able to prove that they have introduced some of those tools helped them to secure some contracts with the international companies who started to really pay attention to whether there is some due diligence on this issue in their supply chain. The way that we've organized the toolkit was basically developing tools for each of the stages of the human rights due diligence. So we've got tools that are helping to assess impact and whether company might be in danger of actually using forced labor, and that are looking into how to minimize this process. So we've got tools that are helping to raise awareness of the stakeholders. And Elena will probably paste into the chat as a links to some of the leaflets that we've also developed. We've also provided some very specific tools that like questionnaires that help to monitor the situation. And there is also information what to do when you get the results back. So basically, we've kind of designed the whole toolkit, and you can see kind of, and I apologize for the lack of sharpness on the picture, but we've developed the whole toolkit consisting of 10 plus tools along the human rights due diligence cycle. So we start with assess and plan. So for example, if the company is at the stage when they know that, okay, we need to increase our workforce because we are coming close to Christmas and we need some extra workers, then they need to assess, okay, are we going to employ those people directly, or are we going to use agencies? And if we are going to use employment or recruitment agencies, what shall we check? How can we make sure that we are actually cooperating with a legitimate organizations that is really trying to make good business, but also respect people's rights and the right to work? Or are we dealing with some fraudulent agencies that basically is abusing workers? And we had a number of cases in Poland also proved in the courts that where actually there were some agencies which were not even registered in the official registers, and that were used by the companies without the latters knowing that actually they are using the work of people who are actually being abused and who are in the situation of forced labor. So this is kind of the first part. Then second is developing contractual clauses that will enable you as a company or as a contractor. I mean, it can be also public administration. I mean, also public administration in Poland does use also employment agencies and so on. So it doesn't have to be necessarily private sector. So basically, you have to develop contractual clauses to be able to secure yourself possibility of conducting audits and so-called third-party audits in your suppliers or in the agencies, and to make sure that you can do either interviews or that you can review the data. In Polish case, we also developed specific tools, like consents that workers would need to sign to make sure that actually this company can request data concerning their personal data. Then also at this very stage, it's a stage where you need to start raising awareness of the people who are coming into the company. They might not know what forced labor is. They won't probably know the local regulations in Poland or in any other country. And we've talked some time ago with Olena that insurance system, health insurance system works differently in Poland. There are different rules concerning what you actually get in terms of salary on the contract. In Poland, you will get so-called gross remuneration, but in reality, you will be getting lower pay, net pay, because from gross one, you've got tax and insurance deducted. So it all differs. And it's important that people know what is okay and what is not. And having those leaflets that you distribute to people at the entry when they come for the first time to your company is really important, because if they don't know what is okay and what is not okay, and if they don't know whom to contact in case they are abused, I mean, they won't turn to you for help. And the next time you might learn about the situation is basically when you got summoned by the prosecution. So it's in the company interest to actually try to identify such cases earlier on. Then it's a time for check. So you need to kind of follow up. If you wanted to have audits, follow up with an audit. You don't have to do it with all the suppliers, but do it occasionally with one to several, depending on your capacities. But do make sure that you actually check it. Your suppliers will learn from each other that, oh, it's not just written on paper, that next time it might be them. So even if you can't do checks on all the suppliers, just make sure that you address it at the few. It's also a good time after 2-3 months when people are working with your company through the agency to actually have a survey and check if they are receiving their salaries on time, to check if their documents are not being held up, if they can move around freely, what are the conditions where they are living, if they live in some accommodation provided by the agency, and so on. And then when you gather this data, it might show you that, well, okay, there are some inaccuracies, there are some infringements of the labor law, but they don't necessarily amount to the forced labor. But there might be cases, and there were such cases that we know of, where basically you've got a very strong signal that it is a case of forced labor. And that's where you basically need to turn to the prosecution services or turn to Lastrado or other foundations that can help you and assist you in undertaking the right steps. Because it's also, there were cases where people were, violators were notified early enough, and then basically the people who were abused disappeared, either being sent back to their country or something else being done, being relocated to some other places where they were still abused. So it is important to take care also at this last stage of undertaking action after acting. And basically, this is a recurring circle. It's a continuous improvement. So along the assess and plan, do, check, act model. So nothing really new for the companies. They do it all the time. This is an approach they take on a number of issues. It's just a matter of changing the mindset and kind of making it very clear to companies that it's not one miracle solution, to kind of like, okay, we've got one miraculous tool for preventing forced labor. No, it's basically a number of activities that need to be taken at different stages by different people in the company. And those will be different units and different responsibilities and functions that will be responsible for assessing the risk of forced labor being in the system, in the company, and responsible for undertaking action. So, at the beginning, when you want to agree conditions of cooperation with external actors, it will be purchasing unit, somebody from legal and compliance or CSR unit even, really depending on the size of the company. The toolkit was developed in a way to make sure that it can be used also by small and medium enterprises. Therefore, we've even provided surveys ready with questions and response sheets, coding sheets in Excel, so that it really can be used by small companies without extra time dedicated to developing the toolkits and tools. And what is important, you've seen that, yes, we had this very nice printed and available also in the PDF version booklet, but more importantly, we've got all those tools available in editable formats, available on the website, and they can be just downloaded and used straight away without retyping or doing things. And I think it's also very important when you think about what can be done by the Ukrainian administration or Ukrainian companies. I think that's also very important to kind of make sure that it's not only that the tool is developed, but that it's actually made user-friendly. And just an example of one of the tools, it's a questionnaire of initial risk assessment. And you kind of ask, we have questions like, is your organization active in the public sector? Is it providing, does it lead activity in the construction, production, and so on? A number of questions where we know that are of higher risk, where there is higher risk of forced labor in Poland, and so on. And so there are a number of questions also concerning some internal policies of the companies. Because if the company has an internal policy concerning risk management in specific situations, it already will be able to spot some issues. So it's already a point in favor. So just to show that those are really specific tools, something and tables that companies are really used to. And I think that is important elements that you need to kind of make it friendly, user-friendly also for business. In terms of information that you can seek, like one of the questions that we had, from which countries will be the worker, how are the workers will be coming to your country, the country of the operation. And basically you can check the risk of the forced labor at source through even reviewing some generally available data. Obviously, it won't tell you if this will be the case of this person, but if you know that you will be sourcing a group of workers from Turkmenistan, which is very high on the risk of on the list of risks in terms of forced labor, you know that you'll need to take extra care and also verify the agencies that you'll be working with in that country. So yes. And just to remind you one thing, why it's so important for companies to do those checks. I think it's often forgotten that forced labor generates 150 billion US dollars per year. And it is business, and as every business, it is risk averse. And therefore, people who are most vulnerable are children, women, migrant workers, seasonal workers, and contracted agency workers. As soon as the company starts to look into the different and ask questions, they do withdraw. They don't want trouble. Trouble means, loss of revenue. And sorry to be so down to earth, but basically, if you are a company and you will start asking questions, you are very, very likely to avoid trouble simply because the other party wants to use forced labor, wants to exploit people, will withdraw. And the more companies are asking questions, the bigger chance that also it will be easier to identify those actors that are contributing to the rise in it. The short films that Elena was trying to show you basically shows that in the course of only last 5 years, there is a 25% increase in the number of people in the forced labor. In 2016, estimates were saying that there are around 40 million people in modern slavery. And now the data shows that it's around 50 million. And the increase in people experiencing forced labor is slightly less. It was 24, I think, and now it's 28%, but around 28 million. But 86% of those 28 million are actually in private sector. And 3.3 million are children. So the numbers are shocking. And I think we really need the action on all sides, both business, but also states. And I think I cannot stress strongly enough, and that's kind of, I'm closing out now. I really can't stress strongly enough the importance of the collaboration between state and different actors, both NGOs and business and academia. And also the importance of collaboration on the side of the administration between the units that work on trafficking in human beings and those who work on forced labor. Because trafficking for the purpose of forced labor is just part of the problem. And if you have in the country only regulations tackling trafficking for that purpose, you won't be addressing half of the problem. You still need to have, if you want to be effective, and we've seen it simply in the Polish courts, how the cases are falling through simply because of the lack of separate crime of forced labor. And yeah, we are trying to work on it. Here, it goes very slowly, unfortunately, but learn from our mistakes. Thank you very much.
Thank you very much, Beata. І я можу сказати, що ми маємо дозвіл в межах.
I should say that the project allows us to translate these tools into Ukrainian. Therefore, this month we are planning to complete the translation and to agree it with the Polish Institute. We are going to ask for the permission to use these tools in the Ukrainians, to disseminate these tools. So once the Parliament's Commissioner's Secretariat will be interested in these tools and the dissemination, maybe some presentation events for the target audience, then definitely we will be happy to extend our cooperation for the sake of the tools dissemination in Ukraine. And with that, I would like to pass the floor to the representative of the Human Rights Commissioner Secretariat, Ms. Svetlana Glushenko. She is the director of the Social Rights Monitoring Directorate. She's got PhD in law, and just like Ms. Beata said, anyway, we have to consider the local context. In the beginning of our webinar, I mentioned that We discussed this topic with the Secretariat, and we agreed on the fact that local context should be taken into consideration when assessing the extent of undeclared work and its impact on the forced labor. Ms. Svetlana, the floor is yours. Ms. Svetlana. Good afternoon, dear participants of the event. Thank you very much for this opportunity to speak in front of you, the chance to share the information we have collected. As the Secretariat of the Human Rights Commissioner, we have lots of data on the labor, on the forced data, yet we would like to look at it in the light of undeclared work and informal employment. These topics are strategic directions for the Secretariat, because you are well aware that the employment form has a great impact on the social guarantees which the person will be entitled to in the future. So this undeclared work is closely monitored by the Commissioner's office. Unfortunately, due to the Russian invasion, we do not possess updated statistics on informal employment. So our data relate to 2021. While monitoring the situation, we can inform you that certain sectors, certain economic activity sectors are characterized by the highest percentage of informal employment. Generally, it's believed that about 3 million of population work in shadow economy. They are informally employed in various economic sectors, and the highest share is in forestries, fisheries, and agriculture. Nearly 46% of the total amount of people who work informally. And the high level of informal employment is also observed in the construction sector and the wholesale and retail. The Commissioner's Secretariat monitored also the State Employment Service, which is in charge of public control and surveillance. In 2022, monitoring revealed nearly 6,000 cases of undeclared work, with nearly 5.5 thousand of them in the private sector. So this means that the private companies, private enterprises tend to hire undeclared workers. And one of the reasons for such situation is that business entities from the first, second, and third group of taxation are not subject to administrative penalties. In the case of a violation, they are the only sanction they face with is the so-called warning. So they are not scared of financial sanctions. Therefore, the private entrepreneurs allow themselves to use this element of undeclared work. However, the undeclared work is one undeclared work has many reasons. So why actually do the companies avoid the declared work? Certain business activity is subject to licensing in the healthcare and the transportation sector. So in order to get licenses, the companies have to demonstrate a certain qualification of personnel, and the personnel should be employed officially, formally, and have necessary skills. So the licenses are not going to be issued unless the employees meet the requirements. However, if cases of undeclared work are revealed, for instance, the workers do not have certain skills, certain qualifications, or educational background, then there are still no possibilities to withdraw the licenses, unfortunately. So in case of violation, the license won't be rebuked. These issues of the forced labor have been relevant before war, and they gain on importance during the wartime. I would like also to dwell on another topic, namely lack of responsibility for the business entities. In such situations, when the public control authority cannot find the business entity at the address indicated during registration. So the business entity may provide, so to say, false data, or the legal address might be changed, and in this case, the control authorities cannot exercise their powers and check the situation with labor relations and the compliance with legislation. In the times of war, our citizens face with the risk of violations. In what way can they protect their rights? Unfortunately, a decision was made that certain measures of public control are not to be implemented. So the inspections are temporarily banned. This means that the labor inspections cannot inspect actually the entities to identify the cases of undeclared work. This means that undeclared workers have to deal with their problems on their own. And the commissioner's office often receives reports and complaints that demonstrate the fact that the workers report and complain only after the employer has violated its obligations. And the citizen has just one way to protect his or her rights. The only available method is the court remedy. It's very difficult to collect the evidence to prove that the person was employed unofficially. What's the problem actually? I would say that our citizens have low level of awareness, but their rights, they do not always ask the employers for documents. They do not read the documents related to their employment. They do not undergo the inception instructions, and they do not require the accounting documents showing or reflecting their salaries. So since this evidence is hard to be collected, they also find it difficult to sue the employer. So due to these circumstances, we tend to discuss the forced labor phenomenon through the prism of undeclared work. I believe that the share of undeclared work has increased during the time of war because those businesses that continue to work, that continue to operate, they pose very stringent requirements, and they say something like either you stay and work or you leave. And the solidarity which we have been discussing today, it's in place, but unfortunately we also register very sad facts. Thank you. Thank you for your attention. Thank you, Svetlana. Yes, indeed. We can now embrace the full picture of the situation. You've seen the tool presented by Ms. Beata. We would like to use it in Ukraine, but definitely we need to analyze it with due consideration of our national context and national challenges. During this webinar, the partners are participating. They are ready to join in this work. For instance, Ms. Marina Kupchuk from the National Contact Point of OECD, and they are also ready to participate in adaptation of this tool and its further dissemination, use, and involvement of all the stakeholders. So thank you very much for your contribution, Ms. Marina. We would like also to learn about the experience of our other neighbors who also faced with the issue of Ukrainian refugees who were forcefully displaced. And I would like to pass the floor to our colleague from Moldova, Mr. Pancho Volchanov. If you're online, please share your experience. Good afternoon. Thank you for this invitation to participate. I'm sorry, I will be speaking in Russian. I'm of Bulgarian origin, and I speak Russian and Bulgarian. Thank you very much once again for the invitation. Very briefly, I will present the situation in Moldova. Moldova is observing an inflow of Ukrainian refugees caused by illegal and unjustified aggression against the Ukrainian people. This crisis is actually the biggest global crisis after the World War II, As a result, millions of Ukrainians were forced to flee their homes, searching for some shelter in the neighboring countries. Moldova has a direct border with Ukraine, just like Poland. And according to the Migration Service data, Moldova hosted nearly 1 million of Ukrainian refugees, or at least 1 million entered Moldova, but the major part of them left Moldova. They migrated farther to Europe, and at the moment there are about 100,000 Ukrainian refugees staying in Moldova. 21,000 of them filed an application asking for temporary protection, and some of them also applied for asylum. We believe that today's situation is terrifying, and it's one of the reasons for instability in the neighboring countries. The largest share of refugees can be considered as transit refugees, and they are very vulnerable in terms of human rights. And due to the technical progress, migration has become easier. However, for many migrants, the journey is long and dangerous. Transit migrants faced with multiple risks of abuse in the sphere of human rights because of their uncertain status. They are quite vulnerable. They do not have any protection in the transit country. Transit migrants from Ukraine are mainly women, 90% of them, because men are forbidden to leave Ukraine. And these transit migrants often face with violence of gender and sexual nature. Child migrants also face with risks, irrespective of the fact of whether they travel on their own or whether they are accompanied by their family members or adults. The hosting countries have obligation to take measures to protect migrants' rights and to support them. Migrants also experience other risks such as illegal or inappropriate profiling, gender violence, or so-called interception. What does it mean? We've noticed that the activity of criminal organizations, criminal groups have intensified. So these clans or these groups involved in human trafficking pretend to be willing to support migrants. They wait for migrants at the border crossing points. They promised, they offered support, and they offered some transportation services. They, for instance, promised to take the migrants to the European Union countries and further. Many migrants who crossed the border in the first days of war did not have the documents with them, and it was a real advantage for the criminal groups. They took their chance, and many migrants fell victims to the trafficking. People did not have the documents, so they were easy price for slavery and trafficking. As soon as we find this fact, we alarmed the border guards, Moldovan border guards, and they started various checks. They inspected the buses, they inspected the companies that provided services of transportation to these forced migrants who were going to leave Moldova as transit country. Moldova was supported by Bulgaria and Romania. They helped with the transportation of migrants who traveled from Ukraine. A special attention was paid to children. Many adults did not have the documents, and some children just could present the birth certificates. And the Moldovan authorities adopted a policy of child identification to prevent trafficking in children. In this situation, Moldova, just like other neighbor countries of Ukraine, created the migration centers that hosted Ukrainian refugees. Moldova received also assistance from other countries to provide these refugees with everything they needed. Moldovan authorities managed to prevent many crimes within a very short period, because Ukrainian refugees were really vulnerable. Many Moldovan farmers and businessmen abused this vulnerability, and Ukrainian refugees were involved in exploitation because they just didn't have the documents. Then again, Moldovan authorities took measures aimed at identifying Ukrainian documentless refugees. The Ukrainian embassy in Moldova started issuing certificates and other documents for Ukrainian refugees to present them, to find a job, or to enroll their children into schools. These measures actually prevented criminal groups from continuing their activities, and due to these measures, Ukrainian refugees refused greater protection, and the human trafficking potential in Moldova has grown significantly. During this period, Moldovan authorities initiated lots of criminal cases, lots of investigations against human trafficking under the article number 165 of the Criminal Code of Moldova. So this article criminalizes the trafficking in persons and exploitation of people for the purpose of forced labor. Under this article, the perpetrators can be punished by from 10 to 12 years in prison, especially in cases where victims are children. Such punishments are quite severe, and the measures taken allowed to reduce the scale of trafficking in persons in Moldova. Back then and now, Moldovan authorities cooperate with some of their European colleagues working on trafficking in persons cases. For instance, recently, Moldova cooperated with the Italian authorities on a human trafficking case. They investigated against a criminal group that took Ukrainian and Moldovan women and children to Italy, and some of these victims were sexually exploited, and some of them were forced to work in agriculture. The Moldovan prosecutor's office has increased and enhanced its efforts. Due to this fact, the number of criminal investigations against these criminal groups has grown. In some cases, the government, the government also consolidated its efforts aimed at protecting victims. However, today we see in Moldova that still the inflow of refugees is very significant. I have a question. I'd like to clarify the following. Do you have any cases of companies, especially big companies, that made their contribution to eliminating the element of forced labor in their supply chains? Because you focus mainly on the governmental efforts. Are there any efforts, are there any achievements of corporations? Since the very beginning, big business in Moldova, corporations in Moldova, made a decision to employ Ukrainian refugees only on the terms of labor contracts. And labor contracts envisage payment of social benefits, and big companies in Moldova from the very beginning rejected the idea of illegal employment of Ukrainian refugees. In Moldova, there are several big companies. One of them produces, for instance, wiring for cars. And these companies are not involved in the use of undeclared work. Main cases main cases were registered in the sector of small business and in the agriculture. Some farms hired people illegally because the migrants didn't have money. Women with children were forced to work every day, and they were not paid enough. They received just food and some money to support themselves while they were receiving their documents from the embassy. I'm sorry for interrupting you. We've got 5 minutes left, so let's summarize perhaps your contribution. Maybe some of our participants have comments, because Beata also wanted to take the floor as far as I understand. So if possible. We've got just 5 minutes left. Okay, 1 minute. We've been observing, monitoring situation for 8 months. And we have identified the priority recommendations that should be applied by both Moldova and other countries. In Moldova, big business invested lots of efforts to avoid undeclared work and exploitation of Ukrainian refugees. Thank you. Thank you very much. And thank you for this analysis in the national context. We are going to translate this analysis as well, and we'll disseminate it. Thank you. Okay, and now, Beata, could you please make a comment to finalize the webinar? I have just one question about the tool, the questionnaires you have developed. Do you have any feedback from the business? Are they active in using this questionnaire?
So that's what I've been told, and apologies, I didn't want to make it a comment. I was just writing that we are talking to the Polish ministry about a possibility of translating those tools into English, because this could perhaps but I was just very I can just sign up to what you said, that it's great that perhaps there will be possibility to translate into Ukrainian. But of course, a number of points in those tools, some of them are very universal, like the questions for internal audit and things that you need to look at, and the indicators which are of forced labor, which are set out by the ILO and so on. But there are some points which obviously you will need to adapt to the Ukrainian context, because in Poland, for example, agencies should register. Employment agencies need to register to operate legally. I don't know how the situation looks like in Ukraine. Obviously, you need to adjust it to the local context. But no, sorry, I didn't want to take time. I was just kind of writing about this, to also trying to put a bit of, let's say, I wouldn't say pressure, but like trying to encourage Polish authorities to do extra work. And it was really interesting to hear also the other speakers. And there are just so many issues that are so interconnected. The gray economy and undeclared work, obviously, people are much more easy to fall into the trap, because it can start like this, and then they find it just impossible to, for example, get the remuneration, because they will be told, well, how can you prove it to me that you've worked for me? And so, yeah, all those issues that were raised today are just, I think it's just really important to realize what we very often see, unfortunately, in Polish administrations. There is this belief that if there is a law, it's respected. Well, it's not the case. The fact that there is a labor code and that companies or other actors should behave accordingly and in line with the labor law doesn't mean that they do so. And this is something where we see there is this lack of understanding sometimes by public administration, which kind of where things are done in line with the law. If somebody has worked for public administration most of his or her life, sometimes it's very difficult for people to understand that in the private sector, this might not necessarily be this way, and that people are sometimes paid with delay. They are paid in rates. They are not paid for some months. I mean, luckily, those are very random and rare cases. But, I mean, things like this happen. And kind of this thinking that, well, the law says doesn't mean that the reality reflects this. And I think particularly public administration should be very open to talking to other actors to actually identify those points and seek solutions, because trying to fight undeclared labor, trying to fight gray economy might actually require looking into what is causing it, and perhaps some other actions undertaken by the administration, pushing people to actually go into the gray economy, because otherwise they just can't make ends meet. And so I think it's very important to look holistically into state actions, state practice, not only law, but also state practice, and also what the market is doing, what companies are doing, and see where those leverages can be applied to improve the situation. It was also very important what Pancho was saying, but I'm afraid I don't want to go into that. I'll just I'm afraid I need to leave simply because my medical leave starts today and I have some formalities, unfortunately, to attend to. But I hope the recording will be available and some notes will follow from that. And I hope we'll have also opportunity to work more with Pancho and others during the project as well. So many thanks.
Thank you very much, Beata. Thank you. Я, власне, дякую всім учасникам.
Thank you very much, Beata, and many thanks to the participants. In case of your questions or reactions or comments, we still may spend several minutes. We are grateful to the Polish Institute and Moldova for cooperation. We will happy to share the tools with the Parliament's Commissioner and with the OECD National Contact Point, because we would like these practical tools to be applied in Ukraine. Once again, many thanks to the International Visegrad Fund that is very supportive of this initiative. Actually, due to Visegrad Fund's support, we are able to develop the tool and to adapt it to our reality. And of course, our gratitude extends to the Secretariat of the Parliament's Commissioner for your openness, for your readiness to cooperate. Indeed, it's a very, I'm really impressed by your enthusiasm at this difficult time. Thank you very much for your time and for your efforts. And our next meeting will start at 3 p.m. CET and 4 p.m. Kyiv time. Our final session will last 1 hour, and our speakers will share their favorite tools in the area of business and human rights. We will meet Ms. Katarina Deikala, Ms. Fedorovich. They will tell us more about the tools and the way of their application. They will explain actually why these tools are their favorites. So see you in 27 minutes. So please come back to our webinar. It's a break now. Thank you very much once again. Thank you.
нашу панельну дискусію про солідарність, права людини і роль корпоративних акторів. І з самого початку наш останній вебінар, назву якого ви зараз бачите на своїх екранах, був саме задуманий як вебінар про інструменти у сфері бізнесу і прав людини, які б допомагали формувати, будувати оцю корпоративну солідарність. Але насправді, з нашої сьогоднішньої ранкової дискусії ми розуміємо, що так чи інакше ми всю корпоративну відповідальність у сфері прав людини маємо розглядати крізь призму солідарності, крізь призму цього принципу. І тому ми, власне, модифікували дещо предмет нашої розмови, і я запропонувала нашим сьогоднішнім гостям поговорити про їх улюблені інструменти у сфері прав людини, які вони мають досвід використання, чому саме ці інструменти для них є улюбленими, тому що насправді інструментів у сфері бізнесу і прав людини на сьогодні дуже багато. Я навіть не буду братися, щоб перерахувати, які існують різноманітні різновиди інструментарію в сфері бізнесу і прав людини. І тому дійсно ми запросили на сьогоднішній вебінар експерток у сфері бізнесу і прав людини, які мають різний досвід роботи з питань бізнесу і прав людини. І кожна з цих експерток дійсно має досвід застосування конкретних інструментів. Тому, власне, я дуже дякую, що сьогодні до нас доєдналася Елла Скибенко, яка є національною дослідницею у Східній Європі і Центральній Азії, представляє ресурсний центр з бізнесу і прав людини, дуже потужну таку агенцію у сфері бізнесу і прав людини, яка також безпосередньо ресурсний центр розробляє такий інструментарій, використовує його, ділиться результатами, і Елла сьогодні нам про це розкаже. І я дуже дійсно рада, що наша дружба в сфері бізнесу і прав людини розпочалася з самого першого круглого столу з бізнесу і прав людини, який відбувся у Національному юридичному університеті в 2017 році, і вже тоді пані Елла ділилася з нами своїми знаннями.
Miss Ella is our long friend who shared her experience, and we are happy to welcome also Ms. Irina Fedorovich, the director of public organization Social Action. She's the founder of innovative directions in the area of business and human rights. She will share her experience. And Ms. Katerina De Calo, she's got PhD in law. She's expert in human rights and business, and she's got huge experience of cooperation with the Helsinki Committee. She's also a researcher, and she has experience of working in an unstable environment in Belarus. With that, I would like to pass the floor to Ms. Ella Skibenko. Ella, what is your favorite tool in the field of business and human rights? Good afternoon, dear participants. I would like to share the presentation.
Дякую. Я б хотіла насправді розповісти про декілька інструментів.
I would like to tell you more about several tools which I regularly use in my activity. And the first tool is designed for analysis of companies working in a certain sector. This year we studied hydro energy, and we studied the mutual allegations of companies that are planning or already operate the hydropower plant in Armenia. Tajikistan and Kyrgyzstan. We also studied the documents, the open source documents, maybe in Russian, Armenian, and English. This is due to our organizational resources. I'm sorry, can everyone see the slides?
Я не знаю, чи мені видно. Елла, а в тебе є ця презентація, бо ти також можеш шерити свій екран?
Зараз я спробую. Це видно мій екран?
Так.
Чудово. От є. Так. Ось, значить, ось це дослідження і
So this is the survey I've mentioned. During the last 10 years, we collected the information for the last 10 years from local media and analyzed them in terms of violations. It analyzed them against 4 major categories: impact on the environment, impact on the communities, civil society, labor rights, and management, and transparency. So that was related to these 4 countries. And main results of this analysis you can see on this slide. Additionally, we have published a tracker. You see how it looks like. It allows us to see what violations, violations were identified. Since majority of these projects are financed by the financial institutions, our major target audience were investors. Here you see that 71% of hydro energy projects which were investigated in Georgia, they are financed by the EBRD, and 67 of hydro energy projects analyzed in Armenia, they are financed by the international financial institutions, inter alia KfW. And no one of those companies which received investment doesn't have public policy on the issue. And then we have referred to the investors who are taking part in these projects with a set of questions regarding the impact of the project or regarding the consultations with different counterparts, and also mitigating the risks arising. And we have published the answers at our website. Why do we do that actually? We actually do that in order to draw the attention to the main risks for the human rights and consequences of these projects, and to draw the attention of the international society and the financing parts, especially taking into account all that problems which are related to the investment to the projects. Also, the representatives of the organization, they use the results of our analysis.
This is an example of one more study which we conducted last year across 30 largest mining companies. I'm not going to dwell on this study because I have often referred to its findings. The target audience, the respondents have been the same, and the goal was similar to the goal of our previous survey. And the next tool I would like to inform you about is this survey. We apply it quite frequently in our activities. Let me give you a couple of examples. On the first day of a Russian invasion, we've been monitoring very closely the reaction of the private sector. And the companies working in the affected regions are obliged to apply the due diligence procedure. And we contacted the companies that work or invest in Russia and Ukraine, and we asked them about the due diligence procedure. Only 42 out of 400 companies provided full or partial responses. 58 companies sent some declarative statements avoiding answers the questions, and two German companies, Volkswagen and Continental, refused to provide the responses. And the main lesson learned is that the companies do not apply the heightened due diligence procedure in Russia and Ukraine. We have analyzed the responses and published the report on the findings. Over the past 7 months, we've been also monitoring public obligations or statements or actions of 42 companies that provided responses in our survey. And here you see the timeline. And it reflects all public statements and particular actions of the companies in response to the Russian aggression in Ukraine. We can draw two conclusions. First of all, still the heightened procedure of due diligence is still not in place, and there is a big gap between the public statements of the companies and their real actions. For instance, they promise to withdraw from the country, but they do not do it. Or they promise that they are not going to buy Russian oil, but then they open their accounts in Russian rubles. Or they, for instance, make statements that they sell essential products in Russia, and then it turns out that they sell ice cream and other similar goods. And again, we are serving the companies. Out of these 400 companies, we would like to ask them what measures they have taken or are planning to take to respond to mobilization in Russia. What's the biggest risk connected with this survey? First of all, low level of response. Of course, it's very unpredictable. For instance, I refer to the survey across 30 biggest mining companies in Armenia, Georgia, and Kazakhstan. In order to conduct this survey, we were forced to change the methodology because at first we tried to survey the companies, but unfortunately got just one response out of 30 companies, notwithstanding all our efforts. The companies did not provide the responses about the policies, environmental policies, and human rights policies. A little bit later, we received some of the responses, but it was not much help, and we start looking for information in the alternative sources. So you always have to remember about this risk when you are planning the survey. And the next tool is called company's response mechanism. We commonly use this tool in our activities. So it's about the inquiries we submit to the companies after we receive reports on alleged violations committed by these companies. So in our inquiries, we ask companies to give their grounds or to provide their explanations. Thus, we help the communities to resolve the problem with human rights violations, and on the other hand, we provide the companies with the opportunity to explain some effects of their economic activity. They get about 1 week to answer, and afterwards we publish the report on alleged violation, and we publish the report of the company next to it. And if the company fails to respond, then we indicate this fact. And as of now, the global share of responses is 63%. Quite recently, we've sent an inquiry to German company Oldendorf, which is accused of shipping Russian coals despite EU sanctions. So the company failed to provide the answer. And whether the company answers or not, has an impact on the company's rankings, so to say, because every company, we dedicate a separate rubric to each company, and there you can see the list of the inquiries and the responses, if such are provided by the company. And finally, I would like to tell you about the reports to special UN procedures. We can submit these reports on our own initiative, or we can be prompted by the activists. Usually we do this when companies commit a series of violations, or it may happen if the company completely ignores the inquiries from the communities and civil society. We may file this report also to special rapporteurs. So what happens in case of such a report? The experts should decide on the further fate of this report or this complaint based on the information provided and the range of their competence. In our case, when they send letters to rapporteurs, we have to explain the allegations, and if necessary, then experts require the authorities to take measures to terminate the violations, or to investigate, or to bring the perpetrators to justice, or to ensure the legal remedies for the affected persons or the victims. The disadvantage of this tool is that it's very time-consuming, so the procedure may last up to 6 months or even longer. And another problem is the feedback. The procedure is regarded as confidential, and it is impossible to get any kind of updates, even for those who file the complaints. Well, actually, I have informed you about the tools which we commonly use and which are my favorites, and they seem to be efficient. However, their application, of course, is highly affected by your goal, and given the goal, you have to select the tool which is most appropriate. Thank you very much. Thank you, Ella. I just was going to ask you whether you monitor the efficiency of the tools applied. It's clear about the reports submitted to rapporteurs, but what about other tools? Do you monitor the reaction provoked by your last year report on the mining industry in 3 countries. Yes, so we communicate with both the governmental and non-governmental actors. We monitor their reactions, and we also try to figure out whether anything has changed after the report. In Georgia, for instance, after the report had been published, the donors community raised the topic of problems in the mining industries. At least this topic has been brought to debate, as if they were not aware about the scale of the problem before. And afterwards, we try to hold trainings or seminars locally for activists, especially who directly monitor the sectors. It's for them to get more information or collect evidence for their activities.
Пані Ірино, будь ласка, яким є ваш досвід роботи з інструментарієм в сфері бізнесу і прав людини?
Дякую, Олена. Доброго дня. Ну, я зовсім з іншого боку буду розповідати, хоча я погоджуюся з тим, що сказала пані Елла попередньо. Дуже б хотілося, щоб компанії відповідали.
Вибачте, а якщо можна, припинити демонстрацію екрану.
Let us stop screen sharing. And it would be cool if companies could respond to questionnaires or presented more information so that researchers had more content to work, to analyze, to think about which instruments to apply. And this year we conducted desk research survey to see what instruments are available for self-assessment, for benchmarking, for risk assessment. Thinking about the future self-assessment for Ukraine, I found a lot of interesting information. It's only about that you need to get data to apply all of these tools. And we need to get this data from those companies that are not always willing to share. So we will further develop instruments, tools for Ukraine. And I hope that by the end of the beginning of next year, we will have something to present. And I am going to speak about an initiative launched by several NGOs, and it is a bit higher level. This is Ukrainian Index of Corporate Equality. This is the idea that appeared in 2015 and it started being implemented in 2016. This is Fulcrum, Nadia, Modern Women. And we have our interpreters working, so you need to slow down. So this idea was about that several NGOs could be brought together, those NGOs that work with various target groups, provide the consultations, advice, that work with gender equality, with women, and so on and so forth, to develop the toolkit for voluntary self-assessment for businesses. This is the questionnaire that businesses fill in order to see how internal procedures, starting with policies and down to practices for these groups, how they contribute to compliance with corporate equality. And of course, we are governed by the Ukrainian legislation, but we also took into account the similar questionnaires that were developed by civic initiatives in other countries. In particular, we were inspired by the process that was launched by Human Rights Campaign in the US. That was a survey for companies, whether they are open and friendly, LGBT friendly, but we decided to focus on 3 groups to have an extensive coverage and not to scare off the companies, because talking to companies back then about their recognition of equality of labor rights and their acceptance and dealing with LGBT, that didn't have much promise. But when they saw several groups, like women, people with disabilities, they recalled that we have quotas, so they could provide some content. The questionnaire is quite straightforward, and there you have actually 3 questionnaires for each categories, but depending on specificity of this audience. So the objective was to see what's available for companies, whether they are ready to speak about the quality policies, and also to inspire the companies to speak about that publicly. And in the first years, of course, that was like that we had to convince the companies to fill in the questionnaire, even though it was straightforward, but we had to convince them of the benefits of filling it out. And the first companies that agreed to participate in the process were mostly Ukrainian offices of large companies that had equality policies, that had something to report on. And the main challenge was convincing Ukrainian officers, Ukrainian managers of those companies that their headquarters have been doing that for a fair amount of time and they have something to share. After year 2 or 3, by and by, large Ukrainian or mixed hybrid companies started joining because they could see that that was something good for reporting, and also it is not scary because mostly this is information in public domain, and the issue is to find someone, some specialist in the company who could fill in that questionnaire, because usually they referred it to marketing and then they try to delegate it to HR, to someone who has enough information to fill in the questionnaire for each of the categories of people, because we ask for a deeper analysis of dealing with this issue, starting with policies and then to including training. Later, in addition to the questionnaire and the rating that we published on the annual basis, we added some activities focused on communication with companies to explain again that this is not scary and that is beneficial. That's about annual HR conferences where we spoke about the index and about good practices, and we invited and guests were invited who could present some case studies. We offered free lectures or trainings, and companies started using that opportunity, especially during year 3. Those were often large international companies that had Ukrainian offices, and they realized that involving civil society organizations into their initiatives would be beneficial for them, because when their headquarters conduct Pride weeks or activities to support gender equality, that they don't need to invite a wheel in Ukraine, that they may just invite NGOs and organize training for their staff. So that was already kind of mutual process, what the civil society could offer to businesses, so that facilitated the process for businesses. Later, there were more structured individual requests from individual companies where they need advice or explanation what to do about that. And the last tool that we developed in the framework of the index, and it was most challenging one, these are so-called audits. Maybe this is not the best definition because it scares companies away, but this is a deeper survey that we conducted with the respective companies when we worked with teams of the companies in order to see whether filling in the questionnaire and internal policies go in line. I mean, they did not just fill in the questionnaire, but we also met managers of the company, sectoral managers, and also in the offices where the companies agreed to that, and also at the companies that had open offices, offices functioning before COVID, where people would come to get some services. That was about accessibility audit. So a team would come to check whether architecturally, informationally, the office was accessible, and then the respective report was developed that we coordinated with the company, and it was public in public domain. So in this way, we tried to showcase this deep check procedure, that it is possible to do that for discrimination issues, and what kind of recommendations could result from that on how to improve, increase the accessibility level, especially if the company plans to move to a new office. They could take those recommendations into account. Also recommendations regarding training of staff and other activities that would help the companies to improve their indicators, because during the years that we've been using this index,
індекси показували зміну результатів, все рівно в будь-якому випадку 100 балів майже ніхто не набирало, тобто завжди було поле для
ever reached 100 points, so there was always room for improvement. So these audits were also aimed at trying to develop more stable relationships with the companies and to talk to them not about just one-time filling out of the questionnaire, but deeper analysis of the processes in the company, whether they implement these equality policies, and if anything could be improved there. That's the work that we did until 2021, and the latest report for 2021 was published last September. There we were supposed to, we planned the presentation for February. That is why we did not do this survey in 2022, and we will discuss it with partners whether we launch that for 2023 and how to reflect that situation of the military aggression, but also deeper and extended due diligence processes, what to pay attention to regarding corporate equality in the context of human resource management, or shall we keep the questionnaire unchanged and just add a couple of questions regarding their functioning, the company's functioning in the war situation. Thank you. I have a very short question before I pass the floor to Katerina. What has changed during the years that you've been developing the index? More companies, fewer companies are participating. Well, more companies participate, right? And we have ongoing participants who do that on the annual basis. They needed no explanation. Companies also approach us with individual queries, requests. So in addition to the companies that undergo the index, we see more local companies, Ukrainian companies, first large ones, then middle-sized businesses. We try to involve SMEs into this survey because we try to prove that this is relevant for any kind of about global companies with extended teams.
Вже з таким простим запитом: а допоможіть нам, там, не знаю, провести аудит, або допоможіть нам організувати навчання, або подивіться, будь ласка, на нашу політику.
Or ask to help them organize training, or they suggest that we analyze their policy. For example, they didn't have particular provisions on corporate equality. We only had human rights policy. So could you check if we do that adequately? So the companies are more open. They may approach us with questions, and I believe that this is the most important progress, because actually filling out the questionnaire is just a little part of that. While asking those questions about routine practices and revising, updating the procedures, that is an evidence of that companies start using those principles that we try to teach them in practice. Thank you, Ira. And Ira participated in our summer business and human rights academy that was organized by the Polish Institute, and the Danish Institute also shared the
компаній. І як завжди постає питання, чи може правозахисна спільнота, ну або громадянське суспільство, яке претендує
civil society that claim being watchdogs, they can collaborate with the companies to assess them and to collaborate with them and to help them. But we will go back to that later. I guess. And now I'd like to pass the floor to Ekaterina Deikala. And with her, we also have those discussions on a regular basis. And Katya, what's your experience of working with the Business and Human Rights Toolkit, whichever language is convenient? Thank you.
Questions in Ukrainian, because I understand absolutely everything. So just can't speak. So as a dog, you know, you understand everything but can't speak. So that's why I have two messages about this in the context of our today's discussion. And the first one, I will start with that my favorite business human rights instrument or tools is that one which is more effective in concrete country for the working with concrete business in concrete situation. Because notwithstanding the fact that there is a general framework and international universal and regional mechanisms, the process of implementing, so acting or not acting, complying or non-complying by business with human rights is going on the ground in concrete country, by concrete business and concrete context. Actually, that is why business itself, to my mind, and the country context and the business itself, as an actor is very important addressee with which we have to work and bear in mind when we are speaking about tools. First of all, because if you want something from some actor, you have to work with this actor to understand what is in his head. It doesn't mean that we have to ask whether business want or does not want to comply with human rights, but it means that we have to understand what is the obstacle. Actually, we have to understand this about all actors and about the state and about the business as well, and about all international mechanisms and institutions. And actually, we have to remove this obstacle. Because the second, actually, I'm deeply convinced, it goes from my general understanding, that more sustained and more long-term results can be achieved only if based on the internal understanding of the actor that this right thing to do, and it's necessary for him to do this. So such a motivation, it will be more sustained. So what does it mean in the context of tools? That means that more effective tool will be that one, to my mind, that not only we consider effective as it is, but which touch the motivation of business. So that is why we, Belarus and Helsinki Committee, when we work on practice with our business and with promotion of this topic in the country, we paid a lot of attention to tools and instruments that can somehow touch the motivation of business. And when we drafted our country guide, it was kind of national baseline assessment, and in the same time, like textbook kind of for business and state and civil society. We tried to cover like the information that can be useful for all these stakeholders. We drafted separately and parallelly the analysis, separate such a brochure on possible motivators for business to comply with human rights. And for example, but again, it depends very much on the country context. So, for example, one of the instrument on which we which we used a lot and to which we referred a lot is a partnership with global business. So I think that is a very good tool, and the global business in this for small local businesses is a kind of tool as well, in the context of being the model and engaging small local businesses in its supply chain. They put frames of human rights compliance, and you as a small local businesses, if you want to work with this global business, and of course every business who wants to develop itself will want to be part of global supply chain, and you will have to follow these rules that almost all global businesses have, and the human rights, which include a human rights frame as well. And actually, we worked a lot with Belarusian businesses, which it was separate target group for us, Belarusian businesses, which were part of global businesses. So we come to them first, and we talk to them. And actually, because it's very simple, because you as a small local business need more this partnership than a big global company, and that's why you will even if you don't understand, or even if you do not agree, even if you don't understand, like, why should I do this, but you will have to do if you want to work with this business. But this tool now, for example, cannot work in Belarus because the country under sanctions, and almost all global businesses have left the country. So small local business now, let's say, doesn't have access to global business, and it's not an argument for them. We use as well this instrument from the other side after protests 2020, after presidential election 2020, and when protests started and all this repressions and so on. We, in November of 2020, the coalition of Belarusian NGO even issued an appeal, separate appeal call, you know how to say, appeal to business, to business who is working in Belarus or with Belarus on any level, to pay attention on all this situation. Actually, this was appeal about business and human rights, about their obligations to search, to look after their supply chain, and to look what is going on in their partners, like Belarusian partners, what they do with their people, with workers, and so on, and actually what they do, how they affiliated with regime or not. So, and it was such a separate appeal of coalition of Belarusian NGO. And after this, we appeal to working actively with global business working in Belarus, referring to it already like with concrete businesses, demanding to ask from their Belarusian partners to comply with human rights. So we didn't ask them to leave from the very beginning. We asked them to use their leverage of partnership, and to especially it was actual for big state-owned plants as partners of global business, because the most grave serious human rights violations have taken place on these plants. When authorities actually practically called the police to force people to work, just physically, you know, like when police sustain on you and force people to work who wanted to go to strike, and they tried to stop strike in such a way. So, and all these big plants are partners of some global business. And we have a big case of Yara, Norwegian company Yara, and Belarus Kali is this big plant. And we describe this case in our policy paper, which we drafted after a year of protests about business and human rights context in context of our this crisis, political and human rights crisis. And actually, I would like to share, because I've got such a thing, the Norwegian Helsinki Committee, they issued the paper Doing Business in Authoritarian States, Tackling Dilemmas While Preserving Integrity just recently. And they also described this case of Yara and Belaruskali there. Or for example, another instrument that I personally think very effective one, but which also will not work everywhere, it depends on country context, is public opinion and actually naming and shaming. But again, it can work, for example, only in the country where there is an institute of reputation developed. And for example, in the country where there is no, it doesn't work. So actually, it's just that such examples, but actually, I would say that coming back to authoritarian regimes and authoritarian regime as an environment for doing business and promotion of business human rights agenda is a separate, very specific context and affects topic of tools to very big extent. So, and the second, my message is generally, Ella said already, mentioned this. Actually, I think that all tools can be divided at least into two groups, and choosing always depends on which concrete task we have to decide. So first of all is the tools that need to stimulate business to turn to topic, to influence business, to start to have this human rights optic business who is not in the topic in principle in general. And the second group is tools which can be used while working already with business, which have already somehow involved in the topic, which understands the necessity, but wants to know how to do it better. For example, human rights impact assessment incorporated in business processes can be such a tool. And of course, in countries of our region, at least in Belarus for sure, the most cases is the first task. So to involve business, to just to business sometimes who, not sometimes, but in most of times, who doesn't see any value of this thing. And of course, after 2020 protests and in connection with co-aggression of Belarus, it became in principle very hard to work. Actually, we have to leave the country, and now actually we practically don't have a state on our side. We never have it on our side, but now we in principle practically don't have state as a function, and actually the set of our tools is not very big now. And today practically we can again we try to use the tool of leverage of global business, even on distance and not being in the country. We are not in the country, but we try to use this when we see some cases which happened in the country. So something like this. Thank you.
Thank you very much. Yeah, it's really very interesting. Я перейду на українську. Взагалі цікаво, що в нашому регіоні
And I'll switch to Ukrainian. In our region, unfortunately, there are not too many tools such as strategic litigation or strikes against the companies. How can we explain this phenomenon? Of course, I'm not asking about Belarus. We know the reasons why.
To have possibility of strategic litigation, you have to have the rule of law. working well, and the interest of the victim. So who will do the strategic litigation? Who agree to have his case as a strategic litigation? And here we faced with legal culture not very developed of people, because it's also a problem. Actually, the problem is that strategic litigation is also, to my mind, an instrument which can't work separately. Like, you have strategic case, and but you don't have institute of reputation. You don't have so. It can happen that you will have this case, even if you have pretty much more or less normal court, but you will have, what will be after this? Will this strategic litigation really strategic? Is the question, if you don't have other elements of normal environment, democratic, which usually have in democratic state, as a division of power, at least normal and not formal, but real division of power, a state which understand the importance of human rights policy, of promoting human rights and actually including human rights in all aspects of people's life and the economic, in all economic process. State who understands that today we can't do any good, we can't be successfully developed economically state if you don't comply with human rights. You can't do normal economy without complying with human rights. This is the axiom for today. And if you don't have all this strategic litigation, I mean, if all businesses, other businesses see that they can be successfully without all your human rights, they will say, oh, okay, the guy is not lucky, so, but we can, but we will. So I think that it's a question of complexity of ecosystem when we're speaking about effective promotion of business human rights in general.
Thank you for your answer. Ірина, будь ласка.
Дякую. Питання не тільки в розподілі влади.
Thank you. It's not just about the division of power and the availability of appropriate power. Speaking about Ukraine, we as a civil organization have the right to initiate strategic litigation. However, there are several challenges. I'm not talking about lawsuits against the companies, because it's very difficult. It is important, it's difficult to find the sufficient number of plaintiffs, so the persons whose stories will be the basis for the litigation. We are looking for the plaintiffs for years. It's the most difficult task. And the second challenge is related to education or awareness, so to say. Everyone is willing to get education. Everyone is willing to work in the European Union. So I mean, the lawyers, the barristers, but nobody wants to start working here in Ukraine. And there are not too many lawyers who have enough national practice, and not too many of them who have courage to promote human rights in the country. It's and we do not see a high number of complaints against the employers. So once again, this is the signal, the fact that people do not have trust to courts. I do not know actually where people file their complaints, maybe employment service, but we have studied court registers and some court decision. We realize that their quality is very low. So on the one hand, people have lack of trust to the court remedies. On the other hand, the lawyers community is also not ready to promote these cases and to use them for strategic litigation. Therefore, these are impediments actually for the processes. So we do not see major cases of strategic litigation, lawsuits against the big companies. As to the labor protection, there is still a very small number of cases. There are some cases related to harassment at the workplace, gender inequality, and inappropriate advertising. By the way, the case law is very interesting in this aspect. There are two competitive directions, so to say. So, on the one hand, the court says that they do not have expertise, and that's why they cannot consider the case. On the other hand, there is a bulk of decisions made by the court based on the analysis of the advertising announcements. So the court tries, so to say, to fulfill its duty. There is also the aspect of the quotes introduced for hired people with disability. Actually, in some sectors, it is not possible to fill this quote, and there is some resistance demonstrated by the people with disabilities communities, because the employers are reluctant to create all conditions for employing the people with disabilities. But still, there are some cases when both employees and the employers claim that the rights to these quotes are violated. Well, I think that it is also very difficult to find the cases related to discrimination, in spite of the fact that we've got the law on discrimination. Since the human rights are not fully reflected in legislation, I believe it's difficult to look for the relevant cases. Yes, I know that the cases, really vocal cases, are quite rare. I know that one company was sued because of inappropriate environmental impact assessment. But as a result, the company started suing the activists of the civil society organization because they claimed the lawsuit resulted in their reputation damage. But finally, the case was resolved in favor of the civil society organization. And there is another case. The company was sued because of a violation of OSH standards. The company distributed food or other goods using the carriers, and the carriers did not use the helmets, and there was no other personal protection equipment, and so on and so forth. But again, this company sued the lawyer who initiated the litigation. But these are sporadic cases which can be monitored from time to time. I'm going to pass the floor to Katerina again, but I'll also ask Ella, why doesn't your resource center consult the companies? But first, Katerina.
I just want to comment a bit on what Rina said. So actually, if we're talking about the trust to the court, that really is very big problem, and in Belarus as well. Is also the part of normal division of power, not formal but real. Because if in the countries there is a division of power, the court fulfills its functions properly, people will trust the court. So that's why when I'm talking about institution, when everything is okay with institutions in the country, when the and I think that there is no, in no country of our region, there is such a situation. So we all have these problems more or less. Of course, for example, situation, even if we take before war, situation in Ukraine and in Belarus is very much different, of course. In Ukraine is much better, of course, but still, this is a problem of properly functioning institution. Is a very big because it's a part of rule of law. It's a part of working principles for rule of law. It's a very big obstacle for business and human rights promotion.
Дякую, Катерина. І Елла, я просто чому запитую, тому що в Україні
asking this question, Ella, in Ukraine there is the experience where we do the index or benchmarking at the company, and the company has further expectation that we help them to improve their policies. The Danish Institute, they also had that experience of providing assistance to companies, company assessment regarding the policies and practices in the field of human rights.
Прав людини, які займаються саме консультуванням компаній. Наскільки я
And there are other companies that, other organizations that provide consultations for the company's advice. And as far as I know, even though you have this extended expertise, you do not provide advice to companies. Why the 30 companies from Kazakhstan, Armenia, and Georgia did not go to you, asking you to help them with their problems? Sometimes we provide advice to companies when they address us directly. For example, a German textile company that planned to launch a business in Ukraine, they held risk assessment about violation of human rights, and they contacted me asking for a consultation for an advice, and I provided that for them. But these are just sporadic cases. Recently, it was a Norwegian company that planned before the war to launch a project in Russia, producing oil. So I believe that the systemic issue is the capacity issue, our resources, actually. Because on the one hand, there is a lot of expertise, there is a lot of knowledge, but human resource, well, that's what we lack. And that is why we try to focus more on priority aspects, priority areas. If we speak about companies, and I mean advice for companies, when we held that survey among the companies regarding application of the deepened due diligence procedures, after the survey, the guidelines were published by, developed by the working group and UNDP, and we immediately provided that to them because we have this tool, this very up-to-date tool that explains in detail how to conduct conflict analysis, because based on that survey, we realized that the companies do not have a very good understanding of what that's about, what we expect from them. So in the to the extent that we have the capacity to do that, we try to provide them with some tools. And again, if we immediately tell them that if you have questions, please contact us. And actually, they do contact us, but very few of them, just a small proportion. And that is why I believe that our key approach there, or our philosophy there, is to where we try to identify or find leaders among all the key groups in that area. And I mean governments, companies, investors. So we look for those people who are truly interested in promoting respect for human rights in businesses. And with them, then we work directly. Thank you. You're welcome. Katarina, you're welcome.
I'd like to add that actually, you know, we discussed this question, this topic once with Dirk from the Danish Institute of Business and Human Rights, and his position is that it's impossible. If you have a role of watchdogging, you can't consult companies. If you are consulting companies on like this due diligence and so on, so you can't be watchdog. So because the business will not trust you, like those business, if you want to consult them, they will not trust you. Actually, I can't say that I fully agree with this point of view. And for example, but of course I see the rational thing in this from one side, but from the other side, we, for example, do both. We have we were collecting and we are collecting violations by business, violations of human rights by Belarusian business, and we are going to launch a database, special database with all these cases that we collected. Of course, it will not cover totally completely all cases in Belarus, but what we could find, what we can find. So we will do this soon. But in the same time, we consult also some businesses, and actually I think that it can be combined somehow, especially, you know, when especially when it's not so many people with proper expertise who can do this. You know, that's the problem as well.
Monopolization.
Yes. Yes, because actually, you know, there is now not so many NGOs or experts who is doing systemically with the business human rights topic. Because, for example, there are a lot of small specialized NGOs, some dealing with people with disabilities, with women, with whatever else, but they can't properly, for example, give the picture of situation in the country for business. They can only say about their narrow aspect, but they can't give the situation, the whole situation in the country, for example. And we can. I mean, the Belarusian Helsinki Committee is the only NGO who is doing with this topic in systemically, generally, as a policy, let's say. So, but yes, so that's why it can be. It's a lack of human resources, including, yes, this is also a problem. Yeah.
Дякую дуже. Ну, я не знаю, якщо є ще сили у наших учасників.
Thank you so much. If our participants still have the energy for comments or questions, because we've been working since 9:30 in the morning Kyiv time, so it is quite intense. But actually, I am so grateful to our experts who agreed to participate, to share their experience, expertise, and I'm so happy that we have dared to include this webinar into the agenda, even though it is already busy enough, because we will have a recording of this webinar. We are broadcasting it on YouTube, so there will be access to the webinar in the both languages, to the panel discussion, including the webinar. And actually, I believe that when we go back to this recording, that's going to be a helpful resource in the future for many of those who work in this theme with this topic, and for us as well, because we will be in the position to go back to this discussion, to revisit it. So thank you so much. Thanks to everyone for participation. Grateful to our interpreters. I believe that has been a challenging day for them. And thank you to all of our partners for your support. Thank you sincerely, dear participants. Look forward to the personal meeting next year in Kharkiv offline. Thank you so much.
До зустрічі.
До зустрічі.
До встречи.